Lordship, mentioning one matter, Lordship, we have tomorrow, Lordship. One matter, Lordship, in the circle.
Give it.
Lordship, mentioning for the operation at least on the tomorrow's list.
My lord, mentioning for collection.
Tomorrow to be mentioned.
Item number one, my lord, I for the respondents, my lord, that matter, my lord, lost it. Petitioner is desired to appointed a commissioner, my lord. But this is, I am the appealing for the wife.
They are not here.
Then,
Pass over, chalo.
Then, my lord,
Item number two.
then, my lord, next circuit, my lord.
আর এই যে ট্যাগ যাচ্ছে দেখো না।
One question.
Four.
এই item number 3 তে তো শুধু department গুলো cancel করতে হবে। মানে repeating also personal to that. এটা তো see এই যে we utility to you. John ke okay manifestations.
Paying for short passing.
No, five. Seven.
Seven, I couldn't read out. This is that matter. I was trying to. Well, yesterday I was trying to.
Yes, where's the state?
Yes, she's there.
Sit. Sit for a few seconds. Health is more important than anything. Definitely more than wealth.
10:32, my lord, item 7.
Yes, we are used to sitting at 10:30. In Calcutta also, at least I do that.
Yes. Well, the victim borrowed house building loan from Mandalam Finance Limited last. He failed to repay the loan. The petitioner, being the collection executive, asked for repayment. If you look at the complainant left his home for a week, and thereafter he was found he committed suicide at his workplace. And the co-accused involved in this case has already been granted anticipatory by this honorable court. The charge sheet has already submitted up to court.
306. 306.
107.
Yes.
My objection.
No, one accused is on bail.
Yes, two accused.
Two accused is on bail.
Yes.
Same allegations against this person.
The allegation is of aiding and abetting suicide. Stop. The petitioner says that he has absolutely no role to play in the alleged offense. Stop. The petitioner is a debt collecting executive.
Collection field executive.
Is a debt collection field executive. For
Cholamandalam Finance Limited.
for a finance company. Stop. Upon the victim failing to repay the concerned loan, the petitioner has visited him and requested him to pay up. Stop. The petitioner then made a complaint and disappeared.
Son made a complaint.
Acha. The petitioner then disappeared for a week and was later detected to have committed suicide. Stop. His son,
At his workplace.
at his workplace. Stop. His son filed the complaint. Paragraph. The advocate for the state draws our attention to the material in the case diary. Stop. He leaves the matter to the discretion of the court. Paragraph. We find that one out of the two accused persons has already been granted anticipatory bail. Stop. This petitioner stands exactly on the same footing as that person. Stop. Charge sheet has been filed upon completion of investigation. Paragraph. In our considered view, immediate custodial interrogation of the petitioner is not necessary.
Well, two accused persons were granted admissibility. Two accused persons.
2 out of 3.
Out of.
So it,
Grateful.
item number 8,
chalo.
For the state.
9, 10,
I got the petition. In this case, the petitioner petition allegation that the petitioner have sympathy of the victim's family member. What happened in this case?
what?
Have
Petitioner?
sympathy of the victim's family member. I am saying, Lord, one person died, Lord. Subsequently, Lord, if one person was kidnapped and subsequently he was died. Subsequently died and the FIR has been lodged. The petitioner at the local villages, Lord, protesting the incident, Lord. And Lord, police lodged a sumoto complaint. Subsequently, FRT was lodged. Subsequently, one case has been, Lord, subsequently the Naraji petition was filed, and the second time, Lord, charge sheet was filed. Lord, in both cases, Lord, charge sheet filed, and the petitioner before you lost it is the witnesses of the first case, where the family members, where the victim was died. Yes, in this case, what are the materials against this petitioner? Which page?
Lordship, statements. Page. Starting from page 40. 45, 46.
Page 40.
40, 45, 46.
They are named in the FIR.
I think so.
All the names are not being mentioned by each of the witnesses. Some have seen some have seen some. Names are there.
Page 40 is the statement of the local neighbor.
Neighbors.
How serious is the offense?
59 to 66 injury reports.
59 to?
66. The police personnel were injured.
Oh, 59 to. Yes, what kind of injury?
Khaleesi's lordship.
59 to.
So are all the names mentioned in 40?
Lordship?
All the names mentioned in 40?
No. In 40, there is one statement, then lordship
Then-
43, 45, 46, 47,
All persons are at large.
Yes,
But someone in custody.
some are in custody.
Someone in custody.
Lordship, actually, what happened, the mob pelted stone and other things to the police and the police got injured. They were taking the dead body of a person. Which it was recovered as the dead body was recovered. They agitated that now what is going on? We want justice. That justice. So the police came there and
59. আচ্ছা সকলের নাম
307 is there.
Lordship,
307.
27.
Yes, what is the injury report? Let us
Page 59 to 66.
Any 164 statement recorded?
No,
by
no,
name?
lordship.
So all persons are named in the statement
In the statement, various statements.
by the eyewitnesses.
By,
So we will say that. Charge sheet is not submitted. Charge sheet file.
no, it says lordship, page 85 first.
85.
There has been certain.
Oh, earlier it was not.
Lordship, the final report was there, 85. Subsequently, discharging one, other charge sheet was given. But once again, the court has taken that yellow tag is the re-investigating investigation order. Yellow tag is the order, logically this is the order.
We are not inclined.
Lord, kindly, Miller.
Issue,
The
issue.
local mob, 40 people, Miller, are included.
No, we don't,
Kindly
we
speak.
don't suppose attacking the police.
It was FRT was filed, Miller, initially, Miller.
Are you,
FRT was filed, Miller.
do you
Kindly,
allow me to dictate the order?
Miller, kindly, did they not press the application, Miller? Allow me to not press, Miller.
I'm praying for a Passover, my lord, because the case diary is not with me now.
They are not here.
Well,
The petitioner.
Well,
These are renewal of application under section 438. The change of circumstances is that, my lord, the petitioner number 2 real application has been rejected on 9th of April 2024 and subsequently 24th of April 2022. Few accused has been granted bail, granted anticipated.
No, second time.
Second time. And so far the petitioner number 1 is a third application and there is no change in circumstances. But this is a case under section 302, my lord, due to political rivalry. This incident
No,
has been available.
302, you see, 438 was once rejected or twice rejected.
Once rejected for the petitioner number 2 and twice rejected for the petitioner number 1. 64% have been FIR. And out of 64%, almost 45 to 50% have been obtained anticipated even. Most of them are on anticipated.
Anyway, your application was earlier rejected. Any change circumstance means any new material has come.
After your application of the petition number 2 was rejected, some other co-accused persons were granted anticipatory bail. And you say you stand on the same footing? No. No, not same footing, it says. What will you do? You want to proceed, suffer a rejection?
My lord,
Want to suffer a rejection?
there will be a liberty, I will say. There kindly must be given any liberty, I will surrender. Because the land
liberty is required for that.
What liberty? Go and surrender. Who stops you from surrendering?
Or other administration, no, not this. Not this, not this.
starting. Starting.
Azizul Haq.
My allegation under section 447, 427, 379, 436, 34 of the Indian allegation that the accused person entering into house and ransom the household property and setting up the prices. The allegation, my lord. No one suffered any kind of injury, personal injury, nothing, no injury, my lord. They are neighbor, they have long-standing enmity. For this reason, this false complaint. This is my plea, my lord.
Case
No
number
one-
section 436, which is traveled by the Sessions Court, my lord. Serious allegations of we had
Yes.
set fire on the house, my lord.
These
No
two
one suffered
persons.
any-
This is the statement of the eyewitness, my lord.
Arson.
My lord.
Arson. arsons.
Any burned materials found? Seizure of burned materials?
Bond material scissor list,
Yes, what is the seizure list showing burned materials?
page number 9.
No, but no injury.
No, injury is not there, but they have set fire to the house which has completely destroyed.
That is what is called arson, ARSON.
ARSON.
Any overact on by these two petitioners?
All accused persons are FIR name.
All accused persons are FIR name. No, well, page 7 is
Is witness, eyewitness, madam.
Show us any, Bablu. Bablu, huh?
Bablu Rahman, Ajiul Haq, Bablu Rahman,
Aziz,
Sapna
three
Chando,
petitioner.
Makched Ali.
Shopon or Makche, that's it. Any statement naming Shopon and Makche, because we have found one
No,
statement,
Bablu is the Bablu and
Ajijul.
Ajijul is
they are named.
their name.
No, 3, 4. Arson is a very serious thing, particularly in the rural areas.
Nothing, sir.
You do know.
Nothing there, how this,
That scissor list is.
The petitioners say that they have been falsely implicated. Stop. The complaint is the result of political rivalry. Stop. They have no role to play in the alleged offense of arson, ARSON. Stop. They pray for pre-arrest bail. Paragraph. Learned advocate for the state, comma, while opposing the prayer, comma, draws our attention to statements of witnesses recorded under section 161 CRPC. Stop. We find that the petitioner numbers 1 and 2 have been specifically named by the witnesses. Stop. Hence, comma, considering the gravity of the offense, comma, we are not inclined to entertain those petitioners, essay for apostrophe. Prayer for anticipatory bail. Stop. The application stands dismissed insofar as petitioner numbers 1 and 2 are concerned. Paragraph. However, insofar as petitioner numbers 3 and 4 are concerned, comma, we do not find in the case diary any such incriminating material as would justify rejection of their prayer for anticipatory bail accordingly.
Well, deliberately they have set the fire.
Leave to amend the cost rate. Hey.
One of the case diary, I want your treatment manager.
What,
Long back it was fine.
what can we do?
Yes, ma'am.
15. Statement.
Is what is the nature of
Yes.
injury?
Nature of injury, doctor said he was also confused, that's why he referred to the.
He was
better-
confused.
Yes, doctor confused. Lordship, this is the, that's why I asked for clarification about the injury. He said that I was confused, that's why I am referred to the higher center for better management. although there is a injury, bleeding injury.
Yes, this is what.
কালকে দেখেছিল।
Oh, that means the report is not obtained.
Yes,
Only this is the,
yes.
no, this is the injury report.
Injury.
Okay. Yes, what is the statement of this person? Mogedul Mia? Which page?
তিনজন লোক আছে। লোকমান হাকিম তিনটে পিটিশনার।
Page 77.
Yes.
লোকমান হাকিম, নূর ইসলাম, নজরুল ইসলাম।
Dispute between the land property. One proclamation report also.
হ্যাঁ
One proclamation, another cases report also. Here also, your lordship.
Another case.
His proclamation.
Take back. Dekhe, yes, I'm asking with the statement of this person, the injured person. Page.
Page your lordship 99.
Page
99.
99. We don't have page 99 here.
May I get back? Kevin, my lord.
Total remaining active person, all our family members, some other active
হ্যাঁ
Yes, this is the statement of witness, the statement of the injured.
Yes, your lordship, there is no statement of injury.
So injured person statement is not recorded.
Yes, your lordship.
It's very strange.
And FIR maker is the injured person or
না করে আসলে এখন এখানে এসে বলতে বললে তো একদিন করে দিই হ্যাঁ এটা সবসময় করে দিচ্ছি
yes, so injured person statement is not recorded.
দিয়ে দাও
Yes, please take note. Learned advocate for the petitioner and learned advocate for state of West Bengal are present. Heard learned advocates for the parties. Produce the materials in the case diary. Learned advocate for the petitioner submits that this is a dispute between the petitioners and the de facto complainant, and the allegations made against the petitioner is not maintainable. Learned advocate further submits that charge sheet has also submitted and the prayer for bail made by the petitioner be considered. Learned advocate for the opposite party state of West Bengal objects to the grant of anticipatory bail and draws attention to the injury report. Upon perusal of the injury report and statement of witness of the village, find that although there are allegations against the petitioners, but the statement of the injured person is not recorded by the IO. Thus, considering the fact that charge sheet is already submitted, there is no scope for any further custodial interrogation. Thus, the prayer for bail, anticipatory bail made by the petitioner is allowed.
of extortion.
Number 16.
Hmm?
Defective complaint purchase from vehicle. So I purchased the agreement from the finance company. Thereafter, he sold the vehicle to the present petitioner. This is the allegation. But condition that the present petitioner will pay rest of the installment amount and will pay the money to the defective complaint. Some money was paid, some money not paid.
So according to you, it is a civil in nature.
Yes, money.
Yes, sir.
Civil in nature.
41 a notice issued.
41 a notice, my lord,
Usually it is, if it is up to 7 years.
it is issued.
Now,
my
which
lord-
year is the case of? Okay, it is under the old act, so 41 a exists.
My lord, agreements are there, actually, it's not allowed because when a property is financed to someone, you cannot sell it. So that the defector complaint has done, he has sold the property to this petitioner and who was supposed
Anyway,
to
so
pay
far the
installment.
petitioner is
It's
concerned.
civil in nature,
Civil in nature.
criminal
Yes, sir.
means we are not there, because there are two agreements also.
The allegation is that he's also accused, the person who sold the
No.
car, who sold the car.
He's not the actor, he's the defector complainant. Now the finance company will sue them. Because he is not paying the installments.
Oh, I see. The de facto complainant had purchased a motor car on hire purchase. Stop. He thereafter sold the car to the present petitioner on the understanding that the petitioner shall pay the remaining installments. Stop. The allegation is that the petitioner has stopped paying the installments. Stop. Hence, the present complaint paragraph. We have heard learned counsel for the parties. Stop. The dispute appears to us to be of civil nature. Stop. Considering the facts and circumstances of the case, comma, in our opinion, comma, custodial interrogation of the petitioner charge sheet
Charge sheet not.
may not be necessary so long as the petitioner cooperates with the investigating authority, investigating officer.
Item number 17. Idea of 198 and 323 and 15 malad 307 and section 34 of the Jalpaiguri. 198 allegation number 307 Jalpaiguri. Petition is the husband malad and allegation is totally false malad. Medical did not support the story of physical and mental torture malad. The story of doubt is totally false malad. I will call. Dispute is purely matrimonial in nature. I will cooperate.
What is that?
Injury is simple and 164 of the victim is recorded, page 22, charge sheet pending. And also the accused statement also recorded. There are specific mention the name of the present petitioner.
Yes, statement of the victim.
22 page.
All other enlarged and anticipated will by the latex.
After 2 years of marriage, she was tortured.
It a victim to man? Victim. Oh, somebody needs him.
Page 22.
Page 22, lords. Yes, yeah, this is this.
Signature of the victim.
And also accused neighbor statement also recorded, page 15 and 16. Subject pending, Lordship. And also accused neighbor statement also recorded where it is mentioned that the husband tortured after 2 years of marriage.
Some allegations are there, but considering the nature of injury, whether 307 is maintainable. That is the question. Nature of injury.
The petitioner is the husband of the victim lady. Stop. The allegation is that the petitioner used to torture his wife regularly. Stop. The victim lady is the de facto complainant.
Yes, Lordship.
Stop. Paragraph. The petitioner says that the allegations are all false. Stop. In any event, comma, custodial interrogation is not necessary insofar as he is concerned. Stop. All other accused persons, being the family members of the petitioner, have been granted anticipatory bail. Stop. Paragraph. We have seen the statement of the victim oblique de facto complainant and the injury report. Stop. The injury report prima facie does not support the prosecution case. Stop. Paragraph on an overall consideration of the nature of the disputes between the parties and the material on record, comma, we are of the view that immediate custody and interrogation of the petitioner is not necessary so long as he cooperates with the investigating officer.
Lordship, I am for the prayer. Lordship, in this case, out of 2 applicants, Lordship, during the pendency of this application, one petitioner number 2, that is Police Chandra, was apprehended by the police. Why not the petition? Because the petitioner number 2.
Infructuous. Infructuous as far as the petitioner number 2 is, yes. Number 1,
Number 1, Lordship.
what is the nature of injury?
Well, 3 persons were assaulted, out of that 2 injuries are severe. Well, page number 18 and 19, yellow pages. Second from the last bottom, my lord. Paragraph.
In this case, 4 accused persons named in the FIR, out of which 2 has already been granted anticipatory bail by the Lord Session Judge. We are. And civil dispute is prevailed between the parties and case and counter case is there. And counter cases, all these petitioners are saving. This is the counter plus of the case which was filed. Kuchliwadi case number 84.
But the injuries are severe, my lord.
Yes.
Even there may be counter cases, but the injuries
No,
are severe.
allegation against these 2 petitioners. No, petitioner number 1.
Petitioner number 1, 2 has been arrested. my lord.
Yes, petitioner number 1. What are the allegations?
Page number 11, 10, 11, 12, my lord.
They have been named.
Charge sheet has been submitted.
Ki naam?
Pablo.
Bablu. All the petitioners named in there.
Who is the victim statement or witness?
Witness, my lord.
Hearsay. Hearsay. Victim statement.
What is victim?
Victim was Umesh, in the injury report, the name.
Yes, injury report is there. The victim
11,
statement.
12, my lord.
Page 11.
11.
That is Laltu Rai.
No, my lord.
What is the name of the victim?
In the injury report, Umesh Rai and some yellow color page.
Umesh Rai was injured.
Umesh Rai and another person is there.
Protima Rai.
Another page, another victim is there, page number 23. 23, my lord.
No experience.
His injury is simple. That's why white paper. Yellow are severe injuries.
This Protima Rai and Umesh Rai.
My lord.
Victim
let us see that.
statement. Where is victim?
Umesh Rai
Statement has
statement.
not been made.
But charge sheet
is submitted.
victim statement not recorded.
That's matter page number 10, 11, 12.
There is the statement of the witnesses,
Witness.
victim statement.
Not
Learned advocate for the petitioners says that the petitioner number 2 has already been taken into custody. Stop. Therefore, this application for anticipatory bail has become infructuous insofar as that petitioner is concerned. Stop. This application stands dismissed insofar as the petitioner number 2 is concerned. Paragraph. The petitioner number 1 says that he has been falsely implicated. Stop. Out of 4 accused persons, 2 have already been granted anticipatory bail. Stop. He stands exactly on the same footing as that person. Stop. He prays for anticipatory bail. Paragraph. We have seen the material in the case diary. Stop. And stop now, including the injury report. Stop. One victim appears to have suffered simple injury, and another appears to have suffered severe injury.
Who has suffered?
2 severe 2 and 2 victims appear to have suffered severe injuries. Stop. However, strangely, the statements of the victims have not been recorded. Stop. Some statements of some witnesses have been recorded, but they do not appear to be eyewitnesses. Stop. Paragraph. Now, charge sheet has been filed upon completion of investigation. Paragraph. In the facts and circumstances aforestated, in our opinion, immediate custodial interrogation of the petitioner number 1 may not be necessary, so long as he is prepared to cooperate with further investigation, if any.
Nineteen.
Below put the show it.
Charge sheet submitted.
Assaulted by shoe, my lord, assaulted with shoe, and thereafter a 16 years boy committed suicide.
He is the sole accused.
No, 5 accused persons are there.
5 accused
His name is
persons.
the 164 statement.
His name is there in 164 statement. Other accused stand in the same footing.
No, their name was also there in the 164 statement.
No, they are
They were
what?
granted 438.
Where are those orders?
439, this is 438.
This is a case of 300?
One is 164.
Yes, the 160.
The daughter of Bodi Sharma and the girl proposed the boy, and he did not accept it. Thereafter, the call one place. Thereafter, quarrel took place. Thereafter, came to the boy, and all family members went to the boy house.
Who proposed?
The girl proposed. In the allegation, in the affair, and thereafter he committed suicide. This is the allegation.
The name of this is the Orghorai.
Baba, alias Baba is there. Number 5.
All other accused, regular bail. Obtained regular bail.
I am not the principal
Charge sheet file showing him as an absconder.
Absconder. Absconder. The others could not abscond, they were arrested.
All family members.
You ran away.
I am the brother-in-law of the Odina.
16 years boy, my lord, custodial interrogation is.
All family members implicated. There is a dispute between the boy and girl. Therefore, all family members implicated. Boy committed suicide, my lord.
These are all family members.
Yes, my lord. I am the brother-in-law of the Odina.
My lord, had the lady, the girl committed suicide, the thing would be different, my lord. Now the boy has committed suicide, that doesn't mean that the family members will, the girls will be, my lord, getting the benefit, my lord. It says something, my lord, it's a suicide. When a person, it's the last thing. She has struck on the wall, my
There
lord.
is no suicide, there is no direct.
16 years boy, my lord.
There is no suicide, which implicates the petitioner.
Yes, where is the postmortem report?
Page 93.
There's a direct implication of that.
Page 93.
There's a mere assumption. Ingredient of abatement, there is a direct.
Page 90?
3. By hanging.
Yes, what is the age of the petitioner?
Petitioner is about 30.
Petitioner 30. Anyway, there is a love relationship between whom? With the present petitioner. No, this is not a question of love. So assaulted,
Yes.
okay.
In the affair, my lord.
No.
Daughter of Bharinath Sharma.
No, what is the case of the prosecution? That,
Execution, a 16 years boy has committed suicide.
yes.
When he
Who
was hit with the shoe, he was assaulted.
was whose by whom? Which
By all different persons, 5 different persons, who are named in the paper.
5 accused persons started him? And where is the witness who have seen this assault?
Page number
Page
10, 11, 12, 13.
10. This is the eyewitness. Eyewitness, page 10, 11, 12. The girl proposed to him.
This is the allegation. There has been dispute, love relationship, and
No, that is where we are looking into the statements. Who has seen
Any eyewitness?
that this person was assaulted by this?
there is no
There-
suicide, no and injury report, postmortem, there is no injury also, I think, artist submitted, all are on well. There is file.
Hey. The allegation is that the victim, comma, a 16-year-old boy, comma, was beaten up by the accused persons with shoes by the accused persons, and as a result of which, comma, feeling insulted, comma, the victim boy committed suicide by hanging. Stop. The paragraph. The petitioner says that the allegations are all false. Stop. The accused persons, including the petitioner, have been falsely implicated because of disputes between the two families. Stop. The other accused persons were taken into custody but have been enlarged on bail. Stop. Charge sheet filed. Charge sheet has been filed. Stop. Custodial interrogation of the petitioner is not necessary. Stop. He prays for pre-arrest bail. Paragraph. Opposing the prayer, comma, learned state advocate draws our attention to statements of witnesses recorded under section 161 CRPC. Stop. The allegations are general in nature. Stop. The post-mortem report shows that the cause of death was hanging ante-mortem. Stop. There is no injury on the body of the victim. Stop. Paragraph. Considering the aforesaid facts and circumstances and the fact that charge sheet has already been submitted, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates in further investigation, comma, if any.
Stage of investigation, man, NDPS case. Cultivation of opium poppy lordship. The owner of the land. Very early stage, man.
5 years old, my lord. He came to the plot of land. I am not decided adjacent to the.
Charge sheet not filed.
No, just the
No, NDPS investigation চলছে, শেষ হয়নি।
very early stage.
Suffer a rejection then. এসো।
No, please, sir, আমরা পড়ে আছি। পড়ে আছি না? কি বলে বলি না?
21.
Which one? 21? Again, NDPS, huh? On the prayer made on behalf of the petitioner, let this matter stand over till the next circuit.
22.
খুবই খারাপ চলছে। Same prayer order.
22 I am for
জব বাবা।
মামলা বেশি হয়ে গেছে তো নিজে ব্যস্ত ভাই
Yes. না 22 তো ইনার ম্যাটার। তুই কোনটা দিলে আমাদের?
Madam, they were.
Trustee submitted.
On this petition, my lord, he is the owner of the vehicle from which the contraband article was seized, my lord. The driver of the vehicle is in custody, my lord.
No, charge sheet is submitted.
Charge sheet submitted along with CFSL report, madam.
I am the owner of the vehicle.
Showing
From
this
that
petitioner
ground, my lord,
absconding.
I get indicated in
No,
this case,
on
my
the
lord.
statement of the co-accused person, this
He is
person,
the owner of the vehicle. From
is
where
it a commercial vehicle?
commercial vehicle, madam. He is the owner of the vehicle from where the contraband was.
Commercial vehicle, he may not
Commercial,
be-
but which area it was, near his house? This from the vehicle or a remote place?
Madam, just a second. Yes, my lord. Near his house, madam.
Yes, where is this?
My lord, case was initiated in Nagara police station and his house is also in
No,
Nagara.
very well, but where these narcotics were recovered? If the driver was flying the vehicle, in which place it was recovered?
The driver was employed by the owner.
Yes,
Hmm?
yes,
Owner's employee.
yes.
vehicle হতে পারে, driver আমি লাগাচ্ছি, মালগুলো তো একজনের নিয়ে যায় actually.
The owner is Sweets, my lord. He has a sweet shop and the driver.
Charge sheet has been submitted.
Charge sheet, sir.
My lord, in
Yes, please take down.
there is a journey of coordinate.
Learned advocate for the petitioner and learned advocate for the opposite party state of West Bengal are present. Are learned advocate for the petitioner. Learned advocate for the petitioner submits that his client is falsely implicated in the instant case. Stop. Learned advocate further submits that the
there was no recovery from the possession of the petitioner, but as because the petitioner is the owner of a commercial vehicle from where the narcotics drugs has been seized, the petitioner is implicated in the instant case. There are no statements against this petitioner save and except the statement of the co-accused person. Upon considering the facts of the case and the fact that charge sheet has already been submitted and there was no recovery from this petitioner, we are of the view that in the interest of justice, the petitioner should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioner.
Act of paragraph review, Learned State Council opposes the prayer, saying that it is highly unlikely that the petitioner, as the owner of the vehicle from which recovery was made, was not aware of the vehicle being used for illegal purposes.
Yes. And driver is the employee of the owner.
So further, the driver of the vehicle who is in custody is the employee of the owner of the vehicle. It is recorded.
Driver petition also running in the list, item number 156. Well, tomorrow.
That is 439.
439. He is in custody.
23.
I'm for the statement. Not pressed.
Not pressed. Charge sheet filed.
No, my lord, very initial stage.
Five. One, there was a candidate stage 8 of my application. Two persons said two kind of samples. One person found gaja, another person did not find any kind of gaja. Might be specifically this item did not belong to me.
Investigation is going on.
Going on, your lord.
Going on.
And
Issue.
repeated reminder has been sent by the IO but didn't turn up.
Issue.
8C, no lordships. That's why.
They have 180 days to complete the investigation,
Yes,
Mr.
Lordship.
Poddar. The petitioner,
He is the no, my lord. Previously, before start, I stated before your lordships.
yes, show some kindness,
My lord.
quality of mercy.
But they are the
24. Not named in the act. 420, 400, 419, 34 de facto complainant contacted with someone for purchasing gold.
Purchasing gold.
I am not named in the first information report, physical active character and granted bail. I am not named in the first.
Who is named? Who cheated the de facto? What has he said?
But he contacted with
Shindu Kumar.
Yes, ma'am.
You are not named in the FIR. How did you come in? Yes.
A golden color bar on which Jesus Christ cross mark on it, in the middle of one cut mark, weighing about 2 kilos. That was purchased at the rate of 5,65,000.
Was it de facto?
By the de facto.
And thereafter, it was not a gold medal. Later on, he realized that
Purchased from whom?
purchased from Sindhu Kumar, is written medal, Sindhu Kumar and others. And they are the person who are related with Sindhu Kumar on the leading statement of Sindhu Kumar.
That means on the statement of co-accused person.
Charge sheet?
Charge sheet submitted on 13th of September.
Issue. The allegation is that the de facto complainant purchased some gold item from one Sindhu Kumar, and subsequently it transpired that it was not gold. It was not gold. So The petitioner was not named in the first information report. Stop. He has been implicated on the basis of statements made by co-accused persons. Paragraph. The petitioner prays for anticipatory bail, saying that he has absolutely no connection with the alleged offense of cheating. Paragraph. The state, while opposing the prayer, draws our attention to the statements in the statements of witnesses in the case diary. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case and the fact that charge sheet has been filed upon completion of investigation, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he is prepared to cooperate in further investigation, if any.
Is under section 341, 342, 355, 354, 386, 307. My lord, the allegation created pressure upon the defector complaint to withdraw the case. And defector refused. On refusal, the petitioner demand 5 lakh from the defector and locks the door from the outside. My lord, this allegation is totally false. My lord, the previous occasion, the petitioner, the defector complaint lost another case and they are easily got bail.
De facto is a lady.
My lord.
Lady.
Saiful Islam.
My lord,
Effective was Saiful Islam.
Saiful Islam, my lord,
Yes, all 4 persons are FIR named. Yes, what is the injury?
One at least 32 and
Anything serious?
injury is there, but nature of injury is controversial. Not injury is there. Sharp weapon was used.
There was no
We
hospital.
admitted the hospital from 15th March to 17th March.
Victims statement.
Please be aware, at least 40 and 41. 161 statement of one of the main. Was initiated in the year 2006. Subsequent was filed at 2009. They are waiting for that. After 6 long.
So they have been absconding all throughout.
My lord, the petitioner labor, they are working with Kerala. I think working with Kerala. Knowledge about that case. My lord, the previous occasion, another case was lost. They got bail
After that case was initiated.
Another case was lodged by the same complainant.
My lord,
Huh?
my lord.
No, you don't know.
Wow, you see, one people suffer.
Yeah, elections are really adjourned.
Yes, regarding nature of injury, 307 is not maintainable. Nature of injury, cut injury.
You
Nature of injury is not mentioned. But deal of injury, not injury, is there.
Yes, these are the four accused. These are the four accused persons. Okay, learned advocate for the petitioner and learned advocate for the opposite party are present. Are learned advocates for the parties. Produce the materials in the case diary. Learned advocate for the petitioner submits that his clients are falsely implicated in the instant case and the allegations made against his clients are not maintainable. Learned advocate further submits that complaint was lodged under section 156(3) CRPC by the de facto complaint after how many days from the date of the incident? 156(3) CRPC was lodged after 3 days from the date of the incident. Learned advocate appearing for the state objects to the grant of bail and draws attention to the
On the same day.
same date.
Date of offense on 14th March.
And 156(3) CRPC. No, they were admitted to hospital. Complainant is a different person, not the victim. Okay, and on the same date. Learned advocate for the opposite party objects the grant of bail and draws attention to the injury report. Upon the perusal of the injury report, although the details of injury is given, but the nature of injury is not mentioned. Upon perusal of the injury report and other materials in the case diary, and considering the fact that charge sheet is already submitted, this court is of the view that there is, in the interest of justice, the petitioner should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioner. Hence, it is ordered. And petitioner should not enter into the locality. Yes, petitioners will not enter into the locality where the victim resides. Leave it and not leave the jurisdiction of court. তাহলে এটাতে থাকবে চার্জশিট হয়ে গেছে এটাতে থাকবে দিতেও পারে নাও দিতে পারে কিন্তু আমরা দিয়ে দিচ্ছি আর Oh, it cannot leave India without the previous consent. That is the ঠিকই আছে and such are the conditions if the two things fit. No, jurisdiction of the court or the trial.
Item number 26.
I know the petition, allegation under section 447, 468, 471, 427, 326, 325, 564 of the the dispute between the employer of the petitioner and the de facto complainant.
The civil suit also be filed, and my lord, the injunctive was granted, my lord. Subsequently, the FIR has been lodged, because OAC already granted by the honorable court. Page number 23, and it should be.
Yes. What injury, Mr. Gupta? Not in the. Okay. Oasis was granted. Same footing. Issue. The allegations are basically under sections 323 of the 325 IPC stuff. The petitioner says that he has been falsely implicated, stuff. A co-accused person has been granted regular bail by this court. Anticipatory bail by this court. Stuff. He stands on the same footing as that person. Stuff. Paragraph opposing the prayer from a level state council draws our attention to the material in the case diary. Stuff. We find that there is no injury reported in the case diary. In fact, that was the primary ground on which the other accused person was granted anticipatory bail. Paragraph in the facts and circumstances. Charge sheet. In the facts and circumstances, stated, we are of the view that immediate custodial interrogation of the petitioner may not be necessary. So long as he cooperates with the investigating officer. Pursuant to our earlier order, the investigating officer is present in court with the case diary. The personal appearance of the officer is dispensed with. Sure. I think you will cooperate with him.
27. I got more than 36 or 34 of the university of Calcutta. And more suffer in case of the
Yes, 436 is there. All these are FIR named.
Yes, sir. All are.
Yes, what are the
All are
allegations?
FIR names and the petitioner of the FIR name across all are petitioner and sit by the deputy government house and serial list also mentioned where the household articles bond serial list is mentioned. All are FIR numbers. And 161 of the neighbor of the deputy government recorded was page 7, 8, 9, 10. Where the mention of all the petitioner name. Page 7, 8, 9, 10.
Charge sheet is submitted.
Charge sheet is submitted.
Regarding 436, some bond materials are recovered.
Yes,
Bond
sir.
articles.
Bond household articles.
Indian.
So only 436 is non-bailable, triable by the court of
Yes,
session.
All are
Yes, what is the statement of this?
Statement 7, 8, 9, 10.
7, 8, 9, 10.
All petitioner name are there.
Okay, but this bond articles are recovered. So how can it be absolutely false?
All accused petitioner name mentioned in the 160.
Arson is very severe.
So basically, what is
political false content. There is no
It's
photograph.
recovery,
There is
burn
no
title.
photograph. How many days it was recovered? Can you consider what the article was?
नाम कोई कोई तो है लेकिन नाम नहीं आते अभी जून को बहुत अच्छे दर तो बड़ी कुछ नहीं कर पा रहे तो कंपनी का हम लोग जाते हैं तो फिर साइज हो गए नहीं ये तो साथी रहेगा कि किसी नाम लगा के नहीं लगा अच्छा
So general allegations against all of them,
Yes, Lord.
but no special overtact, any particular overtact by any person that is
No.
not there.
All petitioner name are there, Lord.
Yes. Learned advocate for the petitioner and learned advocate for opposite party, state of West Bengal are present. Hard learned advocate for the petitioner. Hard learned advocates for the parties. Learned advocate for the petitioner submits that his clients are falsely implicated in the instant case and the allegations made against his clients are not maintainable. Learned advocate for the opposite parties objects to the grant of bail and submits that the house of the de facto complainant was burned and the petitioners are involved in the case as they are named in the FIR. Upon perusal of the seizure list, it appears that some burned materials were recovered. And upon perusal of the statements of the witnesses, it appears that there are general allegations against all the petitioners and no special overt act is mentioned. Upon hearing the learned advocates and considering the materials in the case diary and the fact that charge sheet is already submitted and hence there is no scope of any custodial interrogation, this court is of the view that as there is no reasonable apprehension to abscond, in the interest of justice, the petitioner should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioners. The condition petitioners shall not leave the jurisdiction of the court and shall not meet the persons acquainted with the facts of the case.
This is my objection.
Yes, that is already recorded.
P26 and 300. There are two petitioner, one is brother-in-law, petitioner number one is brother-in-law, petitioner number two is Christian relative. Both are residing separate household. Husband and the fact of after marriage, they residing in a rented accommodation in the FR estate. We have the brother-in-law. Some of the questions are granted.
My lord, this is the injury report and at page 32 is the 164 of the wife, my lord. Page 32.
Everything is against the husband. Everything. Yes, sure. charge sheet.
Charge sheet filed.
The petitioner number 1 says that he is the brother-in-law of the victim lady, and the petitioner number 2 is a distant relative. Stop. They both reside separately from the victim lady. Stop. They say that they have been falsely implicated in this case. Stop. They have no role to play in the alleged offense. Stop. They pray for anticipatory bail. Paragraph. Learned state advocate draws our attention to the material in the case diary. Stop. We have seen the injury report. Stop. We have also seen the statement of the victim lady recorded under section 164.
164, right?
164 CRPC. Stop. না ওটা তো এখন বিএনএস ওই কি হবে দেখিয়ে দিও, corresponding to 164 লিখে দিও. Stop. All the allegations are against the husband of the victim lady. Stop. Nothing has been stated against these petitioners. Paragraph. In view of the aforesaid and keeping in mind that charge sheet has already been submitted upon completion of investigation, we are of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they cooperate in further investigation, if any. Yes, what is the nature of injury?
Previous lots. This is a photocopy of the victim charge sheet pending lots.
326 is magistrate tribal.
Yes, lots. Charge sheet pending lots.
Case is that daughter of the present petitioner, minor daughter of the present petitioner was abused by the de facto complainant, and minor daughter of the petitioner was thrown to stone.
Injury report page 35.
Thereafter, other protested, thereafter quarrel took place, case and counter case, and one POCSO case also registered against him. Minor daughter of the petitioner was
Against the de facto in this case, POCSO is registered. Which is the first case?
First case, both 20. This was later. We also suffered injury.
Same date.
Yes, ma'am.
Same date.
Yes, ma'am. Both suffered injury, my lord. What father can do when his daughter was as a 13-year daughter, my lord.
Page 35.
Page 30?
35.
Is the sole accused?
No, ma'am.
No, 3 accused.
Okay, 35.
Both husband and wife made an husband, wife, and 3 accused. Minor daughter also made an accused.
Page 35. Backside of the injury report, they are mentioned. Backside.
In the POCSO case, what is the status?
They granted bill, my lord. POCSO, those for this time they granted. For the same.
Yes, and
Charge sheet is pending.
no, this is the nature of injury, okay. And the statement of the victim.
Statement of the victim lordship, page 9 lordship. Basically, name mentioned. Page 9.
Charge sheet?
Pending lordship.
Pending.
Daughter was abused.
Yes, that doesn't mean that such grievous injury would be inflicted. There are ways and means of protecting daughter. The petitioner says that he has been falsely implicated. Stop. No, has been not, has been falsely implicated, stop. There is a counter case instituted by the petitioner's family against the de facto complainant of this case, stop. The de facto complainant of this case physically abused the petitioner's minor daughter, stop. To protect his daughter, the petitioner retaliated, stop. The petitioner prays for anticipatory bail, paragraph. Opposing the prayer, comma, learned state advocate draws our attention to the material in the case diary, stop. We have seen the statements of witnesses recorded under section 161 CRPC, stop. We have seen the injury report, stop. The injury sustained by the victim is grievous, stop. Paragraph. In view of the aforesaid, comma, we are not inclined to allow the petitioner's prayer for anticipatory bail.
Wait for us.
Acha, charge sheet is pending, you say?
Yes, sir.
Oh, total record. In view of the aforesaid and also keeping in mind that investigation is going on and charge sheet is yet to be filed, comma, we are not inclined to.
Item number 30.
Husband? What is the age of the mother-in-law? How did the death take place? By hanging. Yes, Mr. Luxam.
My lord, this is the statement 164 of the mother, my lord. There is no dying situation. Because of the torture, my lord, she committed suicide.
Because of the torture. विष के आप तो hanging or poison?
Poison.
Poison.
But
PM report says so.
PM report is not. Immediate shock due to unknown poisoning.
Unknown poison.
Unknown poisoning and PM is at page number 39.
Only version. The petitioner is the mother-in-law of the victim lady who committed suicide by consuming poison. Stop. The allegation is that due to the torture meted out by the husband's family, comma, the victim lady killed herself. Stop. Paragraph. The petitioner says that all other family members have been granted bail by the trial court. The trial court. Stop. She charge sheet.
Was filed, but regarding RFSL, my lord, supplementary charge is pending.
Charge sheet is filed. Charge sheet has been filed. So, he will see her. She's 52, 54 years of age. Stop. She's fully prepared to cooperate with the investigating officer. Stop. She prays for anticipatory bail. Paragraph. Opposing the prayer, comma, learned state advocate draws our attention to the statement of the victim lady's mother, comma, recorded under section 164 CRPC. Stop. The allegations made by the victim's mother are general and omnibus in nature. Stop. The petitioner or any other member of the husband's family has not been specifically implicated. Paragraph. In view of the aforesaid and keeping in mind that charge sheet has already been filed upon completion of investigation, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary, comma, so long as she cooperates in further investigation, comma, if any. Ashuno. Not to
31.
It is 312.
1 and 4 brother-in-law.
That's the teacher of a Jalpaiguri college. And also and husband arrested now, Kashmir, charge sheets have been made. All family members investigated. After 6 years of marriage.
Yes, what are
Yes.
the allegations?
All are.
So kindly page number 61, Lordship, PM report, Lordship.
PM report.
Yes, Lordship.
Why is it not hanging? Hanging.
Lordship, before hanging, there's the injury, Lordship. Assault. What is assault?
Yes,
Yes.
these
Page number-
persons were residing in the matrimonial home.
All are.
Yes,
No, Lordship, page number 10, Lordship.
Who was not residing?
But brother-in-law, but they are all, after marriage, they all are met, all are.
Statement of the Panchayat Pradhan, Lordship, page number 10, Lordship.
page,
GRO resides separately, Lordship.
page 10.
Yes, 10. Elder brother GRO family resides separately.
That is
Another-
petition number 3 and 4.
No, 3, 4. 1 and 4 brother-in-law.
1 and 4. You are referring to page number 10.
Yes, Lordship. Statement of the Panchayat Pradhan, Lordship.
জিয়ারুল বাড়িতে থাকতো না সেটুকু আছে।
Only one of the co-accused did not reside, that is mentioned.
Yes, Lordship. And Lordship, 164 statement, Lordship, 89, 90 and 91, 164.
Who's 164?
Mother of the deceased.
Mother of the deceased.
Mother
89.
of 89, 90, 91, 3 statement, 164.
Anything specific or general allegations?
From the child, Lordship, of the deceased, they came to know that on the petition has beaten him and hanged him.
Page 89.
89.
Okay.
Treatment of the child?
No, not recorded. Lordship, 4 years. Not recorded.
4 years can speak.
Yes, yes, Lordship. Not found in the city. Lordship.
Because the victim's mother says that the daughter saw.
Yes, yes, yes.
What kind of investigation is
Not
this?
found in the city. Lordship.
This Jairul Haq, the husband is in custody.
Yes, Lordship.
One or 4 থাকতো না। What is the age of the father-in-law? 58. Charge sheet filed. Issue. The petitioner numbers 1 and 4 are brothers-in-law, and the petitioner numbers 2 and 3 are parents-in-law of the victim lady. Stop. The lady killed herself by hanging. Stop. The allegation is that due to torture meted out to her, by the husband and his family members, the victim lady killed herself. Stop. Paragraph. The petitioners say that they have no role to play in the alleged incident. Stop. The husband of the petitioner, of the victim lady, is in custody. Stop. He is solely responsible. Stop. Prepared to cooperate with the police authorities. Stop. They pray for anticipatory bail. Paragraph. Opposing the prayer, learned state advocate draws our attention to the material in the case diary. Stop. We have seen the postmortem report. Stop. We have also seen the statement of the victim's mother recorded under section 164 CRPC. Stop. The allegations are general in nature. Stop. Paragraph. Now, in nature, stop. She in her statement said that the 4.5-year-old daughter of the victim saw the incident of the victim being beaten up and then beaten up, which drove the victim to kill herself. Stop. However, we do not find the statement of the victim's daughter in the case diary. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case, and keeping in mind that charge sheet has already been filed, and also that the petitioner numbers 1 and 4 reside separately from where the victim used to reside, we are of the view that immediate custodial interrogation of the petitioners may not be necessary, so long as they cooperate in further investigation, if any.
302, 201, and 34 of the document. There is a dispute here, whereas rather the impact of complaint was.
Any eyewitness?
My lord, independent witnesses are there, my lord, page
No.
16 to 21.
Against,
Eyewitness?
against this person's
Yes,
eyewitness.
eyewitness are also there.
You're
Very
not
strange.
sure. You are not sure.
Well, independent witnesses are.
This person was a charge sheet.
Not 16 to 21, independent. witness.
Page 16.
16 to 21.
Sorry, we'll just interrupt. Mr. Mujumdar, in two matters, I think you have to file written notes. One is that NDPS matter, remember? And the other is perhaps
Yes. That item
Today-
number 7 probably.
I can know today in the list, it was passed over. Four.
Yes, four.
Four.
No, three. No, the 3 also. This regional man.
Oh, Hiro Sarkar is the NDPS one and Ghanshyam Guru.
Some guru. Regional manager and discipline.
এটা উনি appeal করেন?
Yes, are you appearing in item number 3?
Hiro Sarkar, I am there.
No, right, 4 and 5, but item number 3, this regional manager. This is a disciplinary proceedings matter that is.
You did not appear. Oh, sorry. Item number 3, don't file it at 2 PM then when we come back.
3 and 4. 3, a 4 item.
3 তে কি আছে দেখে নিও তো বাবা। Yes.
Okay, let us see. Yes, page 16.
Page 16 to 21. Or out of 12 accused persons, 11% still absconding, including these petitioners. Investigation still in progress, Your Lordship.
Incident occurred
My lord, on 1st of January 2024.
Yes, so for 16 is concerned.
This petitioner,
No, petition number 2 and 3 is not there.
yes, one is there.
Mizanur Rahman.
Well, here is petitioner. Yes, madam.
Mizanur আর মুর্শিদকে পাচ্ছি না তো। নিজাম নাম তো পাওয়া গেছে 302 ওটাকে বলে কি বিষয় হবে একটাকে the petitioners say that they have been falsely implicated. Stop. They have no role to play in the alleged murder. Stop. They are fully prepared to cooperate with the police authorities. Stop. They pray for anticipatory bail. Paragraph. Opposing the prayer, learned State Council draws our attention to statements of witnesses recorded under section 161 CRPC. Stop. The statements specifically implicate these petitioners along with other accused persons. Stop. Paragraph. We are told that out of 12 accused persons, 11 persons are still 11 persons, including these petitioners, are absconding. Stop. The charge is grave. Stop. There is prima facie incriminating evidence against the petitioners. Paragraph. In view of the aforesaid, we are not inclined to entertain the petitioner's prayer, petitioner's prayer for anticipatory bail. Reject, please.
Malad, this is a renewal of application under section 438.
What is the change circumstance?
Malad, after rejecting this accused petitioner bill, 15 accused person had been granted anticipatory bail by this honorable court. These petitioners had been standing on the same footing, my lord.
So when was your prayer rejected? Last?
My lord, for the petitioner number 1, lastly rejected on 7th of January 2022, and petitioner number 2 has been rejected on 9th of June 2023, my lord. My lord, kindly see page number 23 onwards.
Yes, sir.
My lord,
Shows that, my lord,
What is the nature of injury?
it would be
my lord, dispute between the two political groups, 37% has
due
been
to
acquired.
political animosity.
No, simple or grievous or what?
Simple.
Okay, at that point of time, you see, when was the rejection? The rejection was this. No, I think the rejection of this person.
My lord,
That is page 23.
no, my lord, for the petition number 1
Yes,
is page number 14, my lord.
page 14.
Page 14, my lord. 7th of January 2022.
Okay, let us see page
14.
14.
1.
7th of January. And petition number 2?
Petition number page 16, my lord.
No, no, 7th of January?
2022, my lord.
7th of January.
Page 14, my lord. Annexure P1.
Page 14.
CRMA 14 of 2022.
Victims suffered bullet injury.
And so far the petition number 2, my lord, page 16,
Page 16.
my lord.
What was the ground of rejection? Petition number 2. Arrested for it. Page 16, 1/6.
1/6, my lord.
So, you see, there was the liberty granted to you
My,
for a period of 2 weeks.
You did not surrender.
my
So-
lord, petitioner did not surrender.
So that is 9/6/2023. Within 2 weeks, you did not surrender.
No. My lord, thereafter 15 accused person granted anticipatory bail by this honorable court.
বলো কি করবো বলছে 15 জন এই রিজেকশনের পর 15 জন পেয়েছে ওটা সেম ফুটিং তারপরে সেম ফুটিং আছে সেম ফুটিং
Same footing, my lord.
No, regarding what you say with page 14, that did this victim suffer bullet injury?
My lord, injury report says that, my lord, it was, my lord, injury due to, my lord, gunfire.
Gunfire.
Page 82, my lord, I have.
Page 82.
But out of a political animosity, my lord, between two groups, my lord, the.
all very well but then he should have surrendered by now, particularly when the court directed you to surrender.
That is petition number 2.
That is for the petition number 2. All accused person are on bail. except these two unfortunately. 37% is FIR name, matlab
Bail or anticipatory bail?
anticipatory bail.
Right, these are the same footing.
2 or 3% has been granted bail. All other are.
Charge sheet filed.
Charge sheet file.
My lord.
Charge sheet file.
Issue. The petitioners renew their prayer for bail. Stop. Anticipatory bail. Stop. The prayer of the petitioner, number 1, was rejected on January 7, 2022 in CRM bracket A 14 of 2022. Stop. The prayer of the petitioner number 2 was rejected on June 9, 2023, in CRM A 312 of 2023. Stop. They say that after that, 15 co-accused persons have been granted anticipatory bail by this court. Stop. They stand on the same footing as those 15 persons. Stop. The incident was an outcome of political rivalry. Stop. Rivalry. Stop. Paragraph. Learned State Council draws our attention to the material in the case diary. Stop. He opposes the prayer for bail, anticipatory bail, but in his usual fairness, admits that these two petitioners are similarly circumstanced as the 15 accused persons who have been granted anticipatory bail by this court. Stop. We see, therefore, that there has been change of circumstances after the prayers of these two petitioners for anticipatory bail were rejected. Paragraph. On the ground of parity, we allow this application for anticipatory bail. Correct.
I'm for the statement.
Recovered.
Madam, without wasting court's time, my lord, valuable time, my lord. Kindly see the 164 statement.
Of the victim.
Yes.
Thou
Victim
dost-
recovered. Love relationship is there.
Age of the victim?
20 years.
Yes, yes, let us see.
The court said, yeah. Relevant portion is there.
What, they both ran away?
Family member of the accused, principal accused. Did not.
The petitioner says that there is a love relationship between him and the victim girl. Stop. He is 23 years of age. Stop. The victim is 20 years of age. Stop. They ran away together. Stop. He has been falsely implicated under the pressure of the victim girl's family members. Stop. He prays for anticipatory bail. Paragraph. While opposing the prayer for anticipatory bail, learned state advocate draws our attention to the statement of the victim girl recorded under section 164 CRPC. Stop. The statement completely, prima facie, the statement completely belies the prosecution case. Stop. the victim girl says that she voluntarily ran away with the petitioner and she wants to marry the petitioner. Stop. Paragraph in view of the aforesaid, comma, charge sheet.
Charge sheet, sir.
In view of the aforesaid and keeping in mind that charge sheet has already been submitted upon completion of investigation, comma. We are of the view that immediate custodial interrogation of the petitioner is not necessary accordingly. 35.
Principal charges are under section 117, subsection 274, 109 of IPC.
BNS. What are those in IPC? Corresponding sections?
Section 326, 354, and 307 of IPC, my lord. My lord, the Alex fact is that, my lord,
My lord, all these.
Yes, you tell us
all the
better.
injuries-
Simple.
Simple injuries, page 13 to 33.
Simple. Charge sheet?
Charge sheet not filed.
Not right.
Oh, sorry, wants to move, sorry, extend this. My lord, let him place his case.
Why?
Actually, everything comes from the
He
case
is
diary.
first move, my lord, maiden move, so. let him-
Maiden? Oh, very well. Place your case.
my lord, the Alex fact is that, my lord, dispute between the two families, my lord, issues relating to boundaries wall of landed property, my lord. My lord, case and counter case filed on same date, my lord, over the same incident, my lord. There is no criminal antecedent, my lord.
All right.
And
All right. What should we do? We should allow the application.
yes, my lord.
Taleshu. The petitioners pray for pre-arrest bail. Stop. They say that the incident was an outcome of a dispute between two families concerning land. Stop. They have no criminal antecedents. Stop. They had no intention of harming anybody. Stop. Paragraph. The allegations are under sections are under various sections of the Bharatiya Nyaya Sanhita, 2023, corresponding to mainly sections 326, 307,
Yes, my lord.
354, and
326
IPC. Stop. Paragraph. Learned state advocate draws our attention to the material in the case diary. Charge sheet, you said, has been filed? No. Stop. We see from the injury report that the nature of the injury sustained by the victims is simple. Stop. Nobody suffered any serious injury. Stop. Serious or grievous injury. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case and the nature of the allegations, comma, we are of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they fully cooperate with the investigating officer.
Grateful, my lord. Grateful, my lord.
How grateful are you? Little?
Anyway, you have done well.
More, my lord.
Very well. Thank
Anyway,
you.
it's done well.
36.
But I am for the petition. But these also renewal of prayer of anticipatory bail, man. I am the husband, man. My application earlier rejected on 22nd of May 2024. Kindly see page 9. And my lord, all other co-accused person. they are the
22nd of
in-laws.
May.
Yes, ma'am. 22nd of May 2024.
You have absconded for 14
Yes,
years.
may I say? All other accused person were granted anticipatory bail. I have annexed the order by this honorable High Court.
Did they also abscond for 14 years?
No, Malad.
Now charge sheet submitted.
No, no,
my lord,
case of 2011.
Yes, my humble submission is that, my lord, charge sheet submitted at any condition. I will
No,
face that.
question is, no, question is, you last anticipatory bail was rejected.
That is true. my lord.
When it was rejected?
So 2024, 2nd May of.
24, so what is the development?
No, that is not a problem. my lord. That
This is
true.
the nature, oh, this is a 302. No, question is, had it been only 498A, if there is a chance of settlement, we could have considered.
494.
Right.
Learned advocate for the petitioner and learned advocate for the opposite party, state of West Bengal, are present. And learned advocate for the parties. Learned advocate for the party submits that his client is renewing the prayer for anticipatory bail, which was rejected. Yes, rejected.
22nd of May,
Okay.
2020. Page 9.
22nd May 2024. In CRM A 417 of 2024.
Yes.
Learned advocate for the opposite party objects the grant of bail and submits that the present petitioner was absconding for a long period and hence his prayer for bail may not be considered. Upon considering the facts of the case and the fact that the prayer for anticipatory bail was earlier rejected by this court and the fact that the petitioner has not been able to bring out any new circumstance for further consideration of the anticipatory bail, we are of the view there is no scope to allow the prayer of the petitioner.
Yeah.
Thus, the prayer for anticipatory bail made by the petitioner stands rejected.
Mr. Ghosh, are you supposed to file written notes in 2 o'clock, 2 o'clock, 2 o'clock? Come and before we take up the list, file it. We'll then make it CAV. There's no CD.
And inform the other side also, the other side.
37, no, not today.
38, I want to not press.
Not press. That is excellent news.
39.
After the petition. Now, my lord. This is may I submit your lordship?
39.
39. So for the case is concerned, that is relates to 406, 420 and 120B. No notice was served to me. Now, my lord, kindly see the page number 9 to 10. What is the contention of the FIR? The FIR maker declared himself as the legal heir of his grandfather. Lodged complaint against 18 accused persons, out of which 16 got the privilege of pre-arrest bail. One was arrested, he got the privilege of bail.
Is it your renewal or this
No.
is the first time?
This is the first time.
Charge sheet submitted?
No, my lord. Now, my lord, if your lordship kindly take the FIR, your lordship will find he said during his lifetime, during his father's lifetime, his mother bound to left her matrimonial house and she wanted to take shelter at her paternal house in the story of the FIR. But her fathers and other relatives of her paternal side did not allow her to stay with them.
Irrelevant. What is the nature of cheating?
Civil.
What is the
Oh,
allegation?
so for the nature of cheating, he says, I am saying,
Okay. What are the allegations against this person regarding the?
against all the accused persons standing on the same footing.
What?
Allegation is that they declared that he is not the legal heir of his grandfather. Now, my lord, kindly see, and they sold the property to anyone else.
All these accused
All
persons?
these accused persons. Now, my lord, kindly see the page number 11 of my application.
1 second, 1 second. Just tell us how he stands on a different footing than the 16 persons who have been granted anticipatory bail.
Yes.
Can we have a look at it, Millard? Why this application was rejected? Has been justified by the manager?
My lord, may I submitted one thing? I maybe precisely
Other
say.
accused persons were allowed and,
Allowed.
okay, let us see what are the allegations
Now, my lord,
specifically.
can you see the page number 11?
Yes.
His mother remarried. He also changed his surname and father's name.
Okay, what is the age of this person?
Don't
Page
you-
11.
My lord,
Page 11.
page 11.
Page 11 is the petitioner's admit card.
No, my lord. De facto complaints admit card.
Okay, okay.
De facto complaints admit card. Now can you see, my lord, the page number 16 and 15 and 16. Two paper publication was made by ourselves.
Page 12 is the partition suit.
Personal parties should file a de facto complaint
De facto complaint against?
against ourselves. Now page 16 and 15 and 16,
Yes.
we have made paper publication that we are going to sold that property. If anybody has any objection, raise the same. He did not respond.
Property is already sold.
Already sold.
Yes, the learned trial just justifies. অন্যদের বেল দিয়ে চেক
My lord, he affirmed the affidavit that there are no other legal heirs.
Yes, let us see. Have you collected?
No,
the deed?
mastermind is not.
Have you collected the deed of sale?
Yes,
I-
Your Lordship.
Yes.
Now, my lord, no notice was served to me. Now, my lord, can you see page now 14? 14 and 15. If you, sorry, my lord, 15.
Probir Biswas, Kamal Dee.
We made a general notice, paper publication, in the daily newspaper regarding the sale. But he was remained silent.
Anyway, where is the deed? Deed of sale. Okay, now this deed of sale consists the name of all the accused persons.
All the accused persons,
Yes.
but
Yes.
his bail application turned
Yes, yes.
by the session judge due
Yes.
to that was reflect in the order sheet.
No, no. Where do we get? What is there in from the sale deed? What is in the sale deed from which we can ascertain that he stands in a different footing?
না 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 সেগুলো থেকে পাবে না ট্রায়াল জাজের অর্ডার
My lord,
বিফোর ইন প্রসিডিং এ ওর পিটিশনার একটা ফলস অ্যাফিডেভিট ফাইল করেছে
My lord-
এক্সপ্লেনেশন দিয়েছে যার বেসিসে এই সেল ডিডটা হয়েছে
my lord, one indulgence may I get?
দিও না বিদেশি
My lord, one indulgence may I get, my lord? I am a 68 years old, ready to cooperate with the investigation.
No, you see, now, yes.
No, it
Have
is
you-
an
have you-
allegation.
Have you collected any other documents in the so far the sale deed is concerned?
Now it's a very initial stage, Your Honor.
No, so far sale deed is
There is
concerned,
still going on.
the documents are there, okay? And
In that case, it depends on document.
And
any-
he is trying to play it away from US.
No.
I am 68 years old.
that, you
It
see
is
that.
your version.
No, not my version. This is
condition-
written in the CD.
No, see the nature of the offense, okay? See the nature of the offense. Although under the new law, there is no notice to be issued under 41A, okay? That is,
35-3, my lord.
yes,
35-3,
35(3) of the,
BNS.
where is that? Let us see.
35-3,
Yes, please. BNS 35(3),
35-3.
because under the old act, that
This
41.
is under old act.
So this is old act?
Old act.
No.
This is under old act, my lord.
2024 case.
My lord, this is a case of
September
old act. 420, 406, 123.
924. Case of the registered.
Yes? Case,
924.
so that means under the new act.
But the sections are old act.
No. Question is, you see, sections may be old act, but under the new act, where is that provision?
For 35-3,
35(3).
my lord.
এটা তো ইয়ে ন্যায় সত্য।
BNSS, my lord.
বিএনএস, এটা বিএনএস হলো এটা দিন সুরক্ষা ইয়েটা। হ্যাঁ 35(3).
35-3, my lord.
No, 35(3) is okay.
41 has been substituted by 35-3. No notice was served upon me as on date, my lord. So for my specific information is concerned.
Yes, so far the offences are concerned, it is up to 7 years,
Up to 7 years.
up to 7 years. So 41A or 35(3) can be complied with, and he will attend. If the
Is it about 68 years?
notice
my
is
lord?
received.
Yes. He'll attend.
No. 68 years. So
We will not dispose of this application. We will ask you to serve 41A or 35(3), whatever. We'll keep it before the next circuit. You come back and say whether he has complied with.
in the meantime, my lord, one immunity may be allowed.
Actually,
Certain other
actually, in the meantime, no
documents,
release.
certain other documents has also been executed.
Okay, whatever it is, just.
If he doesn't cooperate, the next bench will, yes, will follow. Sure. The allegations are under sections 406/420/120, capital B IPC. Stop. The petitioner says that all other accused persons have been granted anticipatory bail by the learned trial court. Stop. Stop. He should also be granted pre-arrest bail. Stop. He has no role to play in the alleged offense. Stop. Paragraph. The allegation is that on the strength of an affidavit affirmed by this petitioner declaring a particular property to be to be owned by himself and the other accused persons, a transaction was undertaken selling the said property to the purchaser. Stop. However, the accused persons are not the owners of the said property.
My lord, I am the owner. Co-sharer. We are the co-sharers.
This is the allegation.
Oh, my lord.
Stop.
Maybe excuse.
The said property, or at any rate, not the exclusive owners of the said property. Stop. Paragraph. We are given the nature of the alleged offense and the penal consequences that the same may entail if the accused persons are convicted, we are of the view that the investigating officer should serve notice under section 41A. Corresponding to section 35(3) of Bharatiya Nagarik Suraksha Sanhita of 2023. Stop. This the police will do within a week from date. Stop. Upon receipt of such notice, the petitioner shall act in terms thereof and fully cooperate with the investigating officer. Stop. The petitioner, now, let the matter be listed before the next circuit bench, paragraph karo. Next available circuit bench, stop. Till the last day of the next circuit bench, the petitioner shall not be arrested. Last date ta jobe hobe, kobe hobe ami jani na. Last date. Last day, whatever the last day. এটা আমাকে একটু বলুন, জানি না মানে They are also, you could, you should exhaust the. How does it extremely, so normally 41 years.
Not if, yesterday is not available.
Huh?
Yesterday.
Nahi, chalo not today. State 41,
Okay, definitely.
Application
Renewal application for anticipatory bail. Yes, which sections?
342, 302, 201. See? Paid by somebody.
When was your prayer last rejected?
Ashwin, in the year 2012,
2012.
page number 10 and 11.
When was the charge sheet submitted? 2011? 2015?
50. Page 15.
So you see, what are the new developments? So the case is under 302. Yes, what are the allegations against this person?
Yes, Lordship, that, but actually, Lordship, in the year 2012, this petitioner, bail petitioner, that petition was rejected.
38.
Thereafter, 12 years was abscond, Lordship.
No, any specific allegation? So
Yes, Lordship.
subsequent to the rejection, any bail
No,
develop,
no change, Lordship, there.
trial has not yet started.
Due to the ER and WF and WPF pending against this petitioner.
This. Yes, where is the rejection order? Have you enclosed?
Page number 10 and 11, Lordship.
Page number 10 and 11.
And all the three accused persons, they are till they are abscond.
But other accused persons are already on bail.
That is why here 2003, you know, the same order, they are condemned and they are prepared.
Oh, this is the order granting bail.
No, Lordship, last page. Page number 11.
Okay, maybe time that.
Thereafter 12 years, they are abscond, Lordship, not surrender because the trial.
One could change of circumstance.
Yes, what is your ground for not surrendering during this period?
Petitioners are agreed to cooperate in the investigation.
No, investigation is over, charge sheet is submitted, you have to face trial, but you see, when it was last rejected.
No, madam.
Where is the scope? 2012, it was rejected. What was the ground for not surrendering? Or if there are new circumstances, definitely we can consider.
If they are this presentation, the charge was not submitted. The charge has not been submitted.
After that, you have been absconding for 12 years.
So after the charge sheet, you could have surrendered, or you could have come for anticipatory bail.
This is 302, very
Yes, sir.
serious.
See, we are not going into the merits, okay? So this is the ground, it was rejected. There is a ground which is rejected. Unless there is a change of circumstances, how can we consider? So what do you want? Any rejection order? Or not pressed? So if there is a rejection order, you can go higher forum if you want.
That choice we will give you, because it is your maiden appearance. Maiden appearance. Otherwise, we wouldn't have after full argument.
The petitioner number 1 is the wife of the deceased husband and the mother of 10 years old boy and 3 years old girl. Petitioner number 2 is the brother of the petitioner number 1 and petitioner number 3 is the cousin brother of petitioner number 2.
This is the case on the predominant background of the extramarital relationship with of the husband of the petitioner number one with the neighbor, one Nurima Begum, wife of Moksed Alam. The incident was initially known by the petitioner herself, and it was short to confirm that whether any relationship was there with Nurima Begum or not. That while this was asked for by the petitioner, ultimately that husband of the petitioner disclosed, admitted that yes, admitted there is an extramarital relationship, and he wants to remarry with that Nurima Begum. So there was a altercation by the petitioner number one and her husband, and on that score, thereafter on that Nurima Begum blackmailed the deceased to bring 10 lakhs rupees. Otherwise she will disclose all the things to the society. That was called a heavy harm to their relationship. On that particular day, there was an altercation, and when the defector complained, when the deceased came to the house of the petitioner number one, she sought for one glass of water on that particular day of 31st of May 2024. When she brought a glass of water to offer to her husband, on that spot, he consumed poison on his own. And thereafter, he fell down and he was brought to the hospital. He was admitted in a local.
Who admitted into hospital? This victim?
The victim is the husband of the victim.
No, who admitted the victim to hospital? Whether the petitioner or?
No, petitioner also accompanied all this.
Petitioner also accompanied.
Except three.
Yes, so what are the allegations against?
Where he started for life for 11 days. Ultimately on 6th of June 2023, she succumbed to death.
That is petitioner's husband succumbed to death.
Yes.
Yes. What are the allegations against this?
Thereafter 4 days, thereafter then.
One second, Mr. Chaudhary, have you been informed that the 1 PM matter will not be taken up today? You have not been informed? Yes, no, not today. It's not today. We have same 1 PM. If it's tomorrow, even if we can't do it, we'll reserve judgment.
Number 3 also was on that material point of time was that Kerala for his own occupation. See when he saw the news, when he got the news, he bought ticket and come to the place that there is an annexure of that.
Very well. Let us hear.
Yes, let us see the allegations.
We have heard you enough, Mr. Shah.
161 statement was recorded. You can see all this.
That 161 statement of the brother of the deceased person Miller. He says that the poisoning was a forceful poisoning and deliberately.
Brother, petition number 2 is also the brother.
Brother of the deceased.
No, who is 2? Who is 2?
2 is the brother of the accused wife.
Oh, of number 1.
Yes.
That is brother-in-law.
Yes, brother-in-law of the
So
deceased.
the victim is to reside in his own house or in his in-laws house?
In-laws house.
In in-laws house, the
Yes.
victim is to decide.
Yes.
PM report talks about poison.
Poisoning.
No internal injury or nothing that sort of. 164 statement was also recorded. I said. The eyewitness.
He was in hospital for 11 days, he says. He was not in a position to record any statement.
But probably not. That is why it was not recorded.
Charge sheet filed.
Not yet.
Not yet filed.
Investigation. but there are chances of new material coming. These people are absconding.
No,
I believe that one.
Rajnish has 302 investigation stage finding, charge filed by him. No, no, see, dry allegation removed. After all, it's a murder charge. Investigation is not complete. Anticipatory is included.
164 of the eyewitness can be considered. So 164 of the eyewitness can be
Which is the which page? 164?
Which page?
49.
49.
Lord, may I just indicate one thing? But may I just
Yes,
indicate
164 which page?
page 49. But before your lordship perusal, there is one thing, my lord. The son of the deceased my lord has recorded the 164 statement. He is and was with his mother all along during this time. This lady has not yet been arrested. So, my lord, there are chances, my lord, that this is the tutored version of the 164 statement already recorded. Investigation is going on, my lord. So I have serious objection, my lord, with respect to the petitioner number 1, the lady. With respect to him, I have objection.
Exception because they have relied upon. Prosecution have relied upon. Or his statement.
2 and 3 we can grant.
My lord,
2 and 3 grant. Issue.
So one.
No. Then we reject all 3. The petitioner number 1 is the wife of the deceased person. Stop. The petitioner number 2 is the brother of the petitioner number 1. Stop. The petitioner number 3 is a cousin of the petitioner number 2. Paragraph. The petitioners say that they have no role to play in the alleged offense. Stop. The victim consumed poison on his own and suffered to the and succumbed to the effects thereof after struggling for life for 11 days in hospital. Stop. The petitioners took the victim to the hospital. Stop. They pray for anticipatory bail. Paragraph. Opposing the prayer, comma, learned advocate for the state draws our attention to statements of witnesses recorded under sections 161/164 CRPC. Stop. Paragraph. We have considered the facts and circumstances of the case. Stop. We are inclined to grant anticipatory bail to the petitioner numbers 2 and 3 as prima facie. We do not find any incriminating material against them. And also since the state has no serious objection to grant a bail to these 2 petitioners. Paragraph. However, insofar as the petitioner number 1 is concerned, comma, there appears to be prima facie incriminating material. Stop. Investigation is in progress and charge sheet is yet to be filed. Stop. The charge is very grave, i.e. of murder. Stop. We are not inclined to allow the prayer of the petitioner number 1. Stop. This application stands dismissed insofar as the petitioner number 1 is concerned. Paragraph. Insofar as the petitioner numbers 2 and 3 are concerned, we allow the application accordingly. Oh,
grateful.
We'll come back. My brother has a bench, single bench at 1:10. We'll come back at 2 o'clock. Sorry? Yes. Civil at 3 o'clock today.
Lordship, may I make a small submission, Your Lordship? Lordship, may I request Your Lordship to kindly take item number 29 before Your Lordship rises today?
Why?
There is extreme urgency, Lordship. The lady is suffering from syphilis and she is in custody from last 4 months, Your Lordship. Kindly take up
Possible?
the matter at any time of the day today.
We will try. We may not succeed.
Deeply obliged.
But as they say, failures are the pillars of success.
Yes.
Before we take up the list, yes, notes of argument.
State is also present in this matter. He is in this.
Three or four? Item number 3 or 4? 3. 3, Mr. Ghosh. Yes.
Mr. Ghosh.
Very, 3 তে order record করো. Written notes of arguments filed on behalf of the respective parties be taken on record. So paragraph hearing is concluded. Stop, judgment is reserved.
বিশ্বজিৎ বাবুকে বলা ছিল বিশ্বজিৎ বাবু আপনারা দেখে নিন
Next, please, 4, item 4.
Lordship.
My lord, I am for the petitioner, my lord. This, my lord, along with the written notes of arguments, my lord, I intend to file one supplementary affidavit too, my lord. My lord, with the depositions, my lord. The depositions were inadvertently not annexed in the writ petition. Depo- Supplementary affidavit.
Written notes of arguments filed.
Lordship, just I would like to draw your lordship's kind attention to the fact that I have already submitted Navaska.
All right, this should be on the record.
My lord,
That's Chief Justice Chandrachud.
yes, three judgments. My lord, I have also-
দেখে নাও তো ফাইলে জাওয়াজ খানটার কপিটা আছে কিনা
আলাদা 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 আমরা ওইটাই ওটাই আছে ওইটা না পরে ওইটা And my lord, I have also made one prayer because there are so many conflicting judgments of the coordinated benches. I have prayed that if your lordship deems fit and proper, let it be referred to the Honorable Chief Justice for a record.
If I find that the other so-called conflicting decisions are per incurian in the sense they do not consider the Supreme Court judgment, may not be necessary. Otherwise, we will have to. File on behalf of the respective parties, be taken on record, paragraph, hearing is concluded, stop, judgment is reserved.
But supplementary affidavit may also be taken on record.
Supplementary, hearing concluded, supplementary affidavit filed on behalf of the petitioner, he also keeps it.
I'm grateful.
Thank you.
Item number 43.
Lordship, I am on behalf of the petitioner, Lordship, allegations against me under section 341, 325, 326, 307, 506 and 34. Lordship, no ingredients are there, Lordship, which attracts section 307, Lordship. And I have been falsely implicated without any involvement in the alleged offense, Lordship. Lordship, this is purely civil in nature because petitioner did not borrow any money from the complainant, Lordship, and this is purely civil in nature.
With regard to any contract, any allegations with regard to cheating?
Yes, Lordship. Purely civil in nature, Lordship.
But why 307 then?
Lordship, no ingredients are there. Kindly go through medical, Lordship.
There is no food free.
No, Lordship. 307, 506,
So
34.
how it can be civil in nature, 307?
Lordship, there are no ingredients at all. This is
That
falsely
means the case is
implicated.
not maintainable.
Yes,
It's
Lordship.
not that it is civil in nature.
341, 325, 326, 327.
Nature of injury.
Lord, some medical documents are there, but the injury report is not there. Injury
Yes.
report, no, but medical reports are there. For page
Injury-
41,
Injury report is not there. The incident took place in the month of June.
month of June.
Okay, so anyway, so this
And
is,
161 of, that is page number 5 is there.
Names these three persons.
Yes, madam. They are all named in the FIR.
Huh?
named in the FIR 161,
Page 5, madam.
page 5.
Bolith or Balith, whatever it is, P1 is definitely involved. P2 and P3 is not mentioned. Not mentioned. We have to give these.
Yes, and
P1 we will not. They should. The petitioners say that the allegations against them are false. Stop. In any event, comma, 9 even get the dispute between the petitioners and the de facto complainant are civil in nature. Stop. No criminal action is maintainable. Stop. The ingredients of the alleged offences are not disclosed in this case, are not there. Disclosed. Stop. They pray for anticipatory bail, paragraph. Opposing the prayer, comma, learned state advocate draws our attention to statements of witnesses recorded under section 161 CRPC. So one of them at least, comma, is an eyewitness. Stop. We find no injury report in the case diary. Paragraph. From the witness statements, comma, we find prima facie involvement of the petitioner number 1 in the alleged crime. Stop. We are therefore not inclined to allow the prayer of the petitioner number 1 for anticipatory bail. Stop. This application stands dismissed insofar as the petitioner number 1 is concerned. Paragraph. However, insofar as the petitioner numbers 2 and 3 are concerned, comma, we do not find from the case diary any such incriminating material against them as would justify rejection of their prayer for pre-arrest bail. Accordingly. Hey, take it.
34. On the basis of statement of co-accused, present petitioner implicated principal accused in custody.
Principal accused is?
Custody. Statement of coacus, no narcotics, he was not present at the case of on the basis of coacus statement. my lord.
Nothing recovered.
But investigation not completed.
I will cooperate.
You sure? The petitioner says that there was no recovery of contraband items from him. Stop. He has been implicated on the basis of statement made by a co-accused person. Stop. He pays for pre-arrest bail. Stop. He says that he will fully cooperate with the investigating officer. Paragraph. Learned state advocate, while opposing the bail prayer, says that admits that there was no recovery from this petitioner and that his implication is on the basis of statement of a co-accused person. Stop. He further says that investigation is in progress. Paragraph. Considering the facts and circumstances aforestated, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer accordingly.
I have got the petition. Right.
Forty-five and 47, similar matters, my lord.
Same
From the
case.
same police station case.
Yes, whom did you cheat?
I did not, my lord. 47, the name of the petitioner is
No, we are.
45, lordship, Avinash Jaiswal.
Yes.
I'm not named in the FIR, lord.
Hmm.
Actually, the FIR, in the FIR, the allegation is simply the de facto complainant started receiving calls from various phone numbers, and with a threat that if he doesn't pay certain amount of money to the caller, they will make some obscene videos and send them to his wife and publish them to public domain. This is the allegation, lordship. And in fear of such threats, he paid around 17 lakhs rupees from various bank accounts. I find in the FIR, lordship, only one account, this is Nilmoni Maji. He paid 2,60,000. To whose account, I don't know. I am not involved in this matter, lordship.
Any
The offences, the
specific
punishable-
allegations against you?
No. This is all, I'm not even named in the FIR, lordship. So
Yes,
I will
sure.
cooperate, below 7 years, I'll cooperate with the investigation. The entire case hinges upon documentary
41
evidence
is
and electronic record.
Any notice issued?
41A notice?
41 a notice issued, lordship, but we are in fear that we might be arrested.
No, then if it is issued, go and respond.
Lordship, protect us,
Hello.
protect us, we will go and respond.
Yes.
Protect
There
us.
is a question of protection, my lord. If they are found guilty, they can be arrested after.
Kindly
no.
protect us, lordship, until
Matter
they
will be
protect
kept
us.
pending, okay.
Matter will be.
Matter will be kept pending.
Protect us.
No, my lord. Thing is
No,
that
no,
at the time of complying, they have received the notice.
No, this is
Time of
their
complying,
intention.
If they found that there is sufficient material, so they can make a checklist and they can forward the accused before the nearest station.
You see, where there is no 41A, more than 7 years also, we have granted anticipatory bail.
Lordship,
We can also grant anticipatory
This is a
bail.
Kindly grant
Without that
anticipatory
condition.
bail, lordship. I'll
The
cooperate,
case
I'll
of
fully cooperate,
some
lordship.
Amount of 17 lakhs 34,000.
Not
He
from,
might be not be in them in the FIR, but he is the main
these
person.
are all bank account transfer, lordship.
His
Yes.
name came.
Okay, give us the statement.
This is not
against
booty
person.
of dacoity, lordship. This is the bank account transfer. Entire case hinges upon documentary evidence and electronic records.
It's extortion, okay, cheat and
Nowadays,
extortion.
these things, my
Mr.
lord,
Chakraborty.
my lord,
We were trying to take a course where he will at least go and
my lord.
help you in the investigation. If he doesn't, we'll cancel
Yes,
we'll lift the protection.
lordship,
That is why we'll keep it pending before the next circuit.
My lord.
lordship,
Sure.
in both the matters.
The allegation is under sections 419 oblique 420 oblique 384. Oh, 384 oblique 120 capital B IPC. Stop. The petitioner says that he has absolutely no connection with the alleged offense of cheating or extortion. Stop. Notice under section 41A CRPC. has been issued to him. Stop. However, he has not responded to the notice out of fear of being arrested if he goes to the police station. Stop. He is, however, willing to fully cooperate with the investigating officer. Investigation is going on. Paragraph, no, officer, stop. He prays for anticipatory bail. Paragraph, learned state advocate draws our attention to the material in the case diary. Stop. He says that investigation is in progress and the petitioner's prayer should not be allowed. Stop. More than rupees 17 lakh was the de facto complainant was coerced to pay more than rupees 17 lakhs. Stop. Paragraph. We are of the view that since for notice under section 41 capital A CRPC has been issued, the petitioner should act in terms of the notice and report to the investigating officer. Stop. This he will do within the next 3 days. Stop.
Saturday, Sunday is there.
So what? Police station
Next
is not
3 days.
closed.
Today is Wednesday.
Police station is
Within
not
3 days.
closed.
Stop. Paragraph, let this matter be listed once again before the next available circuit bench. Stop. Till the last day of the next circuit or until further order, whichever is earlier, the petitioner shall not be arrested.
Lodge. Obliged. Obliged.
It's not an answer. Allegation under section 107 of the PNS matter, this is the earlier 305 of the Indian Penal Code. Abatement of suicide of a minor. It's the allegation. In the case matter, there is a love relationship between the petitioner and the minor child. And
There was love.
love relationship. They going to many places. Thereafter, the mother of the present petitioner went to the house of the de facto complainant, scolded and threatened to the victim girl. Thereafter, she committed suicide at her house. This is the allegation. Specific allegation of threatening against the mother of the petitioner.
Just prior to the incident, the mother of this petitioner
Went and scolded the girl.
verbally abused, and the petitioner too over telephone and otherwise verbally abused. And what that is-
405, 406, 305, 305, 6, very weak, really cheated. The petitioner says that he has been falsely implicated in this case. Stop. There was a love relationship between him and the victim girl. Stop. Coming to know of the same, the petitioner's mother went to the victim girl's house and admonished her. Stop. This led to the victim girl committing suicide by hanging. Stop. The petitioner has no role to play in the alleged offense. Stop. Paragraph. Opposing the prayer, learned state advocate says that investigation
going on.
is going on. Stop. Material may be collected against the petitioner indicating his involvement in the alleged offense. Stop. Paragraph. Having considered the nature of the charge and the facts and circumstances of the case, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates fully with the investigating officers. Hey, attack condition.
Forty-seven. 48.
Mr. Rajdeep Mujumdar.
My lord, please permit me to, my lord, appear virtually. My lord.
Yes.
My lord, this is a case, three women there before your lordship's court. My lord, they are praying for anticipatory bail in connection with the case of 302, where the charge sheet has been filed. Now, my lord, your lordship will not find a single specific role. My lord,
They should raise it. Warrant of arrest issued.
Proclamation already completed.
no, my lord, I am covered by your, my lord, I am telling your lordship, my lord, kindly hear me for a moment. The proclamation was issued illegally. And my lord, I am covered by the decisions of this court, which says if the proclamation is issued illegally, then petitioner is entitled to get anticipatory bail. My lord, my junior is there. Two orders, my lord, I shall rely on. My lord, kindly see.
Sanjeev Banerjee, perhaps?
Yes, my lord, your lordship knows better than me. CRM number 7132 of 2018. My lord, kindly see it once.
And perhaps I also followed that judgment.
Yes, my lord, your lordship also followed the same decision.
Counter ruling also. So my lord, it can be fixed on tomorrow, lordships. I will get.
Not today.
Not today.
Supreme Court.
Yes, my lord.
My lord, lavish has been dealt with. My lord, the lavish case has been dealt with. Your
Not
lordship's
today.
order as well as in this order.
Very well, not today.
My lord, some at the fairly top of the list, my lord. They are women, my lord. That is the reason I am telling your lordship.
শুদ্ধ পাঠিয়ে দাও তো পড়বে ওনার কপি করে
এইগুলো প্রোক্লামেশন অর্ডার যেগুলো হয়েছে ওটা মাই লর্ড
kindly make it fairly at the top, my lord.
Let us see, Mr. Mujumdar, let us see.
Well, because they are women, otherwise I should not insist your lordship.
No,
My
is
lord,
the
all
last-
three, my lord, women, my lord.
Chalo.
Think is your lordship, the 164 his involvement is very much.
Not at all, my lord.
Not manageable.
No. Hey.
As your lordship.
49.
49 petitioner.
There was a direction on the prosecution for the compliance in the effect of that will be done.
There was a direction of the prosecution too?
Inform the
De facto.
Oh, there is no order. In the file. Very good.
So revert to serve. My lord. What happened, my lord? My lord, friendship relationship, my lord, developed, my lord, through a.
What are these sections? Tell us the IPC sections.
My lord,
cheating, punishment for rape, voluntary causing heart, theft, criminal act done by.
And my lord,
person of
rape,
common intent.
64.
376.
376 is there, my lord, cheating, theft, and my lord, common intention. My lord, friendship relationship, my lord, developed through a social media. My lord, thereafter, my lord, the victim, my lord, consistently, my lord, my lord, pressurized, my lord,
Is
the
the sole accused?
petitioner, my lord, to get married.
My lord.
That was denied, and thereafter a concocted story has been filed in the form of.
Both
The other
both
two
are major.
164.
Both are major, yes. What is the?
And married, my lord.
Both are married?
Yes, my lord. Both are married.
Both have children?
Both, my lord, the petitioner has children.
Petitioner, I think the victim is a widow or a divorce, settlement
My lord,
was going on.
so far I have been instructed, she's married. Other two accused person have been enlarged on my lord, anticipatory bail.
Medical?
Refused.
Medical refused. Issue. Service report filed by the state evidencing service on the de facto complainant be kept with the record. Paragraph. The petitioner says that he has been falsely implicated. Stop. He came to know, now he is a married person. Stop. The victim, he came to know the victim lady through a social media. Stop. The lady is also a married person, but going through a process of separation with her husband. Stop. Friendship developed between them. Stop. The victim lady started insisting on the petitioner marrying her. Stop. Upon the petitioner refusing, comma, the present false complaint has been lodged. Paragraph. Lodged, stop. The petitioner prays for anticipatory bail. Paragraph. Learned state advocate, while opposing the prayer, investigation not filed. State advocate draws our attention to the statement of the victim lady recorded under section 164 CRPC. Stop. Prima facie, the statement does not inspire much credence. Stop. The lady refused medical examination. Paragraph. On an overall assessment of the material record and the nature of the allegations, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary, so long as he cooperates with the investigating officer.
This is a case while under section
Foreigners Act.
Foreigners Act.
You are an Indian national.
The person was
Abatement.
No abatement. The last point is that one person, one information was received at the police station that one person presenting himself as an Indian is residing in a house of another person, namely Nitai De. The police went to the house of Nitai De and found two persons out there. The main person is Lordship, if Lordship kindly sees the FIR which I annexed in petition, page 14, Lordship. One, Robin De, that is purported to be a son of Nitai De. He and Nitai De were apprehended. And from Robin De, one Aadhaar card was received, another birth certificate bearing registration number 179 was received. Those articles, though Aadhaar card and the birth certificate was seized, and Nitai De, that is the father of Robin De, and the Robin De, who, as per the prosecution case, is Robin Mia, not Robin De. They were and a Bangladeshi citizen. They were Robin De. They were arrested. Investigation started. During investigation, police visited the Gram Panchayat, that is what you can see is page 21. Page 20. That is Tutturi Khando Gram Panchayat office. This is the place where the birth certificate was issued. Now, currently,
Page 21, season list.
Season list. Police interrogated the petitioners here. The petitioners are Dinen, Pradhan and Upar Pradhan of the Gram Panchayat. They interrogated Lordship, from whom says from Anita Lakra, that is one of the petitioners. Now, Lordship, can you see the several documents? They were asked regarding.
Okay, after seizure, they are implicated as accused person.
After seizure, after charge sheet. In the charge sheet, their name came.
Yes, that means after seizure, they were implicated.
So we were asked that how the document, the certificate was issued. We have placed all the documents. So these are the documents they have produced, and basing upon the same documents, the certificate was issued. Now the crux point is that subsequently, silently, the charge sheet was given.
So this is, yes, this is petitioner number 1.
And there is petition number 2 also.
Petitioner number 2, what was seized?
Nothing was seized.
No.
He was Upapradhan. As because Lordship, the name Pradhan and Upapradhan belong to another political party, so charge sheet was submitted. It's not the case, Lordship. Now the crux point is whether the certificate issued by the Pradhan was illegal or legal. The crux point is that if we can show from the document seized by the police that it is as per the procedure of the act and rules, we have issued the certificate. No case.
No, certificate are not fake, but they are issued by these two,
These two
by no petition number 1.
Petition number 1.
It is admitted position that it is seized.
Yes, we have seen. And following the procedure, kindly says Lordship, what are the articles seized from us?
Okay, any other findings against this person, petitioner number 1,
Then section
any statement against?
468, 471, they are the person, they were in the Pradhan and the
No, no.
Upper Pradhan, they are the person on the basis of which they have issued this certificate.
Okay, now any
Rest of
statement?
the documents were prepared.
Oh, no, question is any statement against, so these documents are seized. After seizing these documents from this petitioner number 1, petitioner number 1 is implicated, nothing is seized from petitioner number 2. So now the question is, whatever is seized, is there any findings by the IO that these are all forged documents? Or they have misused their power in using this?
Those are forged documents, those materials are, that's why they are in charge sheet.
Okay, let us see any statements. Now, charge sheet is submitted.
Okay, so the act, that is as per the act, the SDO, executive magistrate is the person who looks after in West Bengal, the birth and death matters. It is, Lordship kindly sees that the SDO has directed to issue the certificates to the BMOH, and upon direction of BMOH, certificate was issued. Documents have been seized by the police.
Or any proceedings is instituted against this petitioner?
No.
As per the
Disciplinary proceedings?
Foreigners Act, why Foreigners Act?
It is alleged that Robin.
468 and 471.
Oh, acha.
That person. Lordship, one
Against other accused person.
One permission letter of SDO Alipurduar, one permission letter of SDO directing the local. We have all direct.
Yes, take down please. Yes, give the CD also, that page. Learned advocate for the petitioner and learned advocate for the opposite party state of West Bengal are present. Hard learned advocates for the parties. Learned advocates for the petitioner submits that the petitioners were not named in the FIR and subsequently they were implicated in the instant case and charge sheet has been submitted. It is further submitted by the learned advocate that pursuant to the arrest of 2 persons being Robin Mia and Nitai De, who are alleged to be Bangladeshi nationals, the investigation was taken out and the petitioners are alleged to have committed offense under section 468, 471, read with section 13/14A/14C of the Foreigners Act. Stop. It appears from the materials on the record that the investigating authority collected register, that is record of birth certificates, one application form issued by block medical officers and different affidavit certificate, voter identity card. Stop. Learned advocate, but no seizure was made from the petitioner number 2. Learned advocates for the petitioner submits that the documents which were seized from petitioner number 1 are forged one as per the findings of the investigating officer. Stop. Learned advocate for the petitioner on the other hand submits that his client petitioner number 1 has issued the register, has maintained the register record of birth certificates and have received the other application and have issued the permission letter of SDO Alipurduar after complying the due process of law. Thus, the petitioner number 1 cannot be implicated in the instant case. Stop. It is an admitted position that all those certain documents which were collected from the petitioner number 1 are alleged to be forged one, but no proceedings, no departmental proceedings are initiated against the petitioner number 1. On the other hand, the petitioner number 2 is implicated, being the Upapradhan, although there is no seizure. Upon considering the materials in the case diary and the fact that investigation is complete and charge sheet is submitted, and upon hearing the learned advocates, this court is of the view that as the petitioner number 1 and petitioner number 2 are the people's representative holding a responsible position, and there is no chance to abscond or tamper with witnesses, in the interest of justice, the petitioner should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioners.
One is female lordship.
That hasn't been called for. Investigation the judge.
Charge sheet been submitted.
Charge sheet has
Submitted.
Jurisdiction, they shall not leave the jurisdiction of West Bengal.
Deeply.
Territorial limits of West Bengal.
If you are,
For the petition number. Well, the allegation under section 85 and 108 of the BNS, the corresponding section is 498A, an abatement of suicide, and that is 306. But the surprising fact is that, my lord, the narratives of the FIR, my lord, says that suicide was attempted. However, my lord, 108 has been, my lord, implicated. She only attempted, my lord. The fact of the matter is that, my lord, the victim lady, my lord, voluntarily relinquished her matrimonial life, went back to her parents' home. There was a negotiation, all efforts were in vain. Thereafter, projecting this false story, my lord, the complaint has been made.
No, but ultimately, he committed suicide.
She is alive, my lord.
She's alive.
She is alive, my lord. This section is at all not maintainable. Only, my lord, so far 85 is.
164 of the victim.
Right. IPC, the IPC.
one is there. 161 of the victim at page 14, 14.
Page 14.
14.
If the victim is alive, how is 306 attracted?
Any injury? Any injury?
Death ticket is there, madam.
That is page.
Page 3. 3 and 20. Page 3 discharge certificate and page 24 bed ticket of the victim.
That is OPD, I think. Of which she was admitted for taking this poison, okay, not for any injury caused.
Issue.
Say poison.
Charge sheet
Charge sheet paper.
pending.
Case of
The allegations are under sections 85/108 of the BNS, 2023, bracketed corresponding to sections 498 capital A and 306 IPC, bracket closed. The petitioner says, petitioners are who?
My lord, the petitioner, the petitioner number 1 is, my lord, the husband. Petitioner number 2 is the, my lord, uncle-in-law. And petitioner number 3, my lord, is one of the relative, my lord, in-laws.
The petitioner number 1 is the husband, comma, the petitioner number 2 is the uncle-in-law, and the petitioner number 3 is another relative of the victim lady who is alive. Stop. Hence, we fail to understand how Section 306 IPC, rather, Section 85. No, 85 is 498A.
85, 498, 108.
How Section 108 of BNS, comma, 2023 could be pressed into service. Stop. Paragraph, we have also seen the material in the case diary. Stop. We are of the considered opinion that in spite of objection raised by learned state advocate, comma, this is a fit case where anticipatory bail may be granted to the petition accordingly.
Here, my lord, allegation under section 140 subsection 3 and my lord 49, 143. My lord, corresponding section is abduction for murder or ransom, and my lord 49 is abatement. My lord, the fact of the matter is that, my lord, that FIR in accused person number 1, who, my lord, may have some relation with the, my lord, victim lady. My lord, the complaint has been lodged by the husband of the, my lord, the victim lady. And my lord, the entire allegation is based upon a hearsay. He has no direct, my lord, source of, my lord, information. And my lord, this petitioner in this, my lord, bail application are the, my lord, the father and mother of the my lord, FIR name accused person number 1. Even
There are 4 petitioners.
4 petitioners.
4 petitioners. Father, mother, my lord, brother, or 2 brothers, and my lord, father and mother. They have no nexus.
The abducted lady has been recovered.
Exactly. My lord, they have recovered, my lord. We have no nexus, man.
Yes, what are the allegations?
Son, who may have some relationship, man. We are the old aged parents, man.
Yes.
Kalisis Lordship, page 26. The 164 statement of the issue.
Page 26.
26.
Okay, this is the this lady was abducted.
Now it is 183 of the
Bangalore.
Right. This person, this lady was recovered from which place?
she was brought once again.
She
And
came
in the
back.
164,
Anyway.
what you will find, there are the materials.
Chloroform or whatever it is,
Sorted by vehicle.
then suddenly she finds herself in Bangalore.
Lordship. And the return is very peculiar. Kalisis Lordship. The voluminous 164. Once again, she sleeps and wakes up in But in medical is on page 17, page 50, 17 is the relevant question.
17.
Naka checking was going on, the vehicle came. She stated to police, myself, I went there. She was taken to the PS. The accused were asked to go home. 160 was statement.
No sign of issue. You are connected, maybe connected with whom? Your son? The person who abducted?
Yes, madam. Yes.
The allegation is of abduction for murder of the victim lady, who is a married person. So, the petitioner numbers 1 and 2 are the parents of the FIR accused person number 1. So, the petitioner numbers 3 and 4 are the brothers of the FIR accused person number 1. Stop. The petitioners say that they have no connection at all with the alleged offense. Stop. They pray for pre-arrest bail. Investigation is going on or charge sheet filed?
Lordship, investigation going on.
Paragraph. Opposing the prayer for anticipatory bail, comma, learned state advocate draws our attention to the material in the case diary, including the statement of the victim girl recorded under section 164 CRPC, and also the medical report. Stop. The prima facie, comma, the story made out in the statement recorded under section 164 CRPC is difficult to believe. Stop. The medical report also does not advance the prosecution case to any extent. Paragraph. On an overall assessment of the material on record and the possible extent of complicity of the petitioners herein in the alleged offense, comma, we are of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they cooperate with the investigating officer.
Based on the section number 448, 307, 34 of the Indian. Dispute between the two neighbors over the issue of constructing a counter. There is a case on counter case. Both the parties were at sustained. We have lost the case earlier, and in that case, they have granted an exceptional by the High Court. But the pregnant wife of the petition number 2 has lost their child, my lord, due to such assault. That girl had miscarried. Kindly see the order that.
Nature of injury?
Not kindly see the photograph. Kindly see the order.
This is the case counter case.
No, no, that is not in the reflected in the case diary. My case diary. That is not reflected. This is the injury man. And my lord, injury report page 23. He was admitted in hospital on 28th of April 2024 and discharged from the hospital on 1st of May. One independent eyewitness, my lord, page 9. 161 statement is there. Page 9 is the eyewitness who saw the incident.
You say you have lodged a complaint also. Did you sustain an injury?
Yes.
Then we should look into both the case diaries together.
I have no knowledge about the counter case number at this stage.
Yes, what is the statement of the victim? Another.
Investigation still in progress.
Yes.
Till that,
No, another. So we have gone through the injury report, the picture, and which statement?
page 9.
Page 9.
Eyewitness.
Hodam Ali Mia is the victim.
Yes.
Okay, page 9.
Page 9. Granted anticipation.
Meet a victim, could
Page,
I?
yes, page 9 is by by witness.
Yes, madam. Eyewitness.
Right.
Who saw the incident?
Okay, that's a counter case, you see, but there are materials.
The petitioners say that there is a prior counter case. There is a prior case filed by these petitioners against the de facto complainant of this case. So the dispute between the parties is regarding construction of a boundary wall. Stop. In the case lodged by the petitioners, the de facto complainant has been granted anticipatory bail. Stop. The petitioners pray for anticipatory bail. Paragraph. Opposing the prayer, learned state advocate draws our attention to the statement of an eyewitness recorded under section 161 CRPC. Stop. She clearly says that the petitioner number 1 herein struck the victim on the head with a wooden stick. Stop. The victim collapsed. Stop. He started bleeding profusely. Stop. Then the petitioner number 2 also dealt a few blows with his hand. Stop. We have seen the injury report and photographs of the victim of the injury. Stop. The injury appears to be serious. Stop. Paragraph. In view of the aforesaid, we are not inclined to allow the prayer of the petitioner number 1. Stop. The application stands dismissed insofar as the petitioner number 1 is concerned. Paragraph. Insofar as the petitioner number 2 is concerned, considering the nature of the material available against him, we are of the view that his immediate custodial interrogation may not be necessary so long as he cooperates with the investigating officer. Sure.
My lord, 54, I am seeking leave to appear online. My lord, am I audible to your lordships, my lord?
Yes.
My lord, I think I'm an imposter today, my lord. My apologies, your lordship will not take me. I mean, my name, your lordship will see a different name, that's why. But my client is not, my lord.
Yes.
My lord, it's a case under 306. My lord, this is a unique one. The petitioner before your lordship is a hotelier. Now, the first informant, my lord, is a local promoter. He wanted to develop a land which was apparently purchased by his deceased wife. Now, the allegation was, my lord, 3 other persons, my lord, who are the co-accused here, used to hurl threat, my lord, to the de facto complainant and his wife in order to grab the land because I wanted to allegedly construct a hotel there. Now, my lord, there is a complaint case filed, my lord, in 2023, in the early part of 2023, where I am not an accused. Now, my lord, on 3rd of December 2023, the wife and the girl child
Mr. Bhattacharya,
my lord,
we would expect you to at least address us from a private place, in a chamber, or you are standing in a public place. Sorry.
my lord, I'm in court, my lord, kindly adjourn, please. My lord, my apologies.
You're on the
My
corridor.
apologies.
We can see
Right, my lord.
people loitering around. Sorry.
My lord, my apologies. My apologies, please.
Not
My
today.
apologies.
Not today. ওই গাড়িতে বসে বিয়ে বেড়াও করে যাও অফিস চেম্বার বা বাড়িতে হ্যাঁ
I'm praying for not to remember.
Makes it. না না ওরা কি করতে হবে নেক্সট কি করে দেবে ও আচ্ছা আচ্ছা তাহলে করতে হবে learned advocate for the petitioner prays for accommodation paragraph on the request made by learned state advocate let this matter stand over till the next circuit.
56, I appear for the petition. My lord, the allegations are under, my lord, section 307, 354, 506 of the, my lord, Indian Penal Code. The sections are under the BNS. My lord, attempt to murder, outrage to modesty, and my lord, hurt. My lord, essentially this dispute has a civil background where a parcel of land is involved. My lord, in that regard, kindly turns to page, my lord, to appreciate the civil dispute, my lord, kindly turns to page 12 of the application. My lord, page 12, para 2. This is a complaint, my lord, lodged by the petitioner against, my lord, the victims and his victim and his family members of this particular case in the month of July 24. They happened to, my lord, obtain a decree of declaration and injunction from a civil court with regard to a parcel of land against the, my lord, victim and his family members. That is, my lord, the genesis of the dispute. Now, my lord, the complaint of this present case is at page 8. Page 8, my lord.
Yes, paragraph number 5. Yes, what are the allegations? Yes, sir. What are the allegations? That is paragraph 5 of the FIR.
Iron rod has been seized. That is not the seizure issue.
Paragraph 5.
First page. That is the seizure.
House of Anil Rai. That is from the house of the petitioner.
No, my lord.
Okay.
Also, my lord,
Okay. From Niloy Rai, this I don't know the road is not from the house of this person.
No,
Yes.
I am Partho Proting De.
Yes,
I am
yes.
not there.
This is the seizure is not from this house of this petitioner. Yes, what are the allegations? That is paragraph 5. Some injury is there.
My lord,
Yes, injury report. Nature of injury is not simple. Nature of injury is simple. Yes, and any allegations? 160.
The 161 statement that is on page 7, 8, and 9 onwards.
Page 7.
7, 8, and 9.
Oh, this is hearsay.
yes.
It's a statement of the victim, injured person.
But as a matter of fact, I was not in the place of offense on the day, my lord. Kindly seize page 19 of my application.
Yes, please take down. Learned advocate for the petitioner and learned advocate for the opposite party, state of West Bengal are present. Are learned advocate for the parties, learned advocate for the petitioner submits that the allegations made against this client are not maintainable and there is a civil dispute between the de facto complainant and the petitioner, and this allegation is the result of such a dispute. Learned advocate for the opposite party, state of West Bengal, objects the grant of anticipatory bail. Upon perusal of the materials in the case diary, it appears that the nature of injury is simple and an iron rod, which is alleged to be the weapon of offense, was not seized from the house of the petitioner, but from some other person's house. Upon considering the nature of injury and other materials in the case diary, and considering the nature of offense and stage of investigation, this court is of the view that as there is no reasonable apprehension to abscond or tamper with the witness, in the interest of justice, the petitioner should be granted anticipatory bail. We therefore allow the prayer for anticipatory bail made by the petitioner. Okay. So do not enter into the land of the de facto complainant. Do not restrain from entering into the land of the de facto complainant, which is the subject of the dispute. আর পুলিশ থানা টানা বলে যার যেরকম ছিল আয় ওকে সিভিল তো
Today's item number 75.
Lordship 57, I beg to appear on behalf of the petitioner.
My lord, item number 70, my lord, state is present. So kindly take.
You decide, we can continue with criminal for the rest of the day.
Lot of matters are being on criminal side. Also can you take some matters?
You tell us, we don't mind.
My lord, item number 70, my lord, kindly take it. My lord, state is present.
3:30 o'clock, also kindly permit.
Up to 3:30. Mr. Advocate, what do you say? You are the leader of the bar here.
What I say, criminal matter is the T20 matches.
Whatever you say, if you say till 3:30, we'll take up criminal, we'll do so.
Yes, let us see. Let us take the civil for half an hour. There are not many matters are not there in the civil side. After half an hour or 35 minutes, we'll come back. That is 3:05. Okay, it will not take the time. I shall restrict you up to 3:40. After 3:40, definitely we'll take up criminal.
Don't do it. তুমি এটাই নাও 3:30 অবধি, তারপরে শিফট করে দিও। না হলে না হলে আধখাঁচড়া হয়ে করে থামিয়ে দিলে ঠিক লাভ হবে না। Very well, call the next matter.
Grateful, man.
Call the next matter.
Grateful. Lordship, item number 57, Lordship, I beg to appear on behalf of the petitioner, Lordship.
Yes.
Lordship, allegation under section 406, 420 of Indian Penal Code, Lordship. Lordship, the allegation is totally civil in nature, Lordship. Lordship, the dispute related to a sale agreement between the parties and dispute regarding 10 lakhs, Lordship. Already 2.5 lakhs has been paid by the petitioner, Lordship, present petitioner. Lordship, come to page number 14, Lordship. Lordship, previously interim bail was granted to the petitioner with a condition that he have to repay whole 10 lakhs within 3 months, Lordship. Lordship, within 3 months, how can a person repay, Lordship? Lordship, I am only praying for give me 6 months time. Within 6 months, I will repay whole amount, Lordship.
You're all mature people. Follow some decorum, some discipline in court. Sounds like a fish market. Yes, madam.
Lordship, may I, Lordship?
Yes.
Lordship, allegation under section 406, 420 of Indian Penal Code, Lordship.
Yes, civil dispute, you said.
Lordship, the dispute regarding to a sale agreement, Lordship. Lordship, the allegation is that, Lordship, the petitioner gone into a sale agreement with a mortgaged property and taken advance 10 lakh rupees. Lordship, Lordship, already 2.5 lakhs I have returned back. Lordship, give me 6 months time, I will be returning back. Lordship,
How
I
did
don't.
he give you 6 months?
No, where is that order granting you three months time? Which page?
Page number 14, Lordship, 14. Lordship, the de facto complainant also stated that I don't have
Page
any
14. Oh, this is
Lordship, page 14. And already, Lordship, a separate proceedings against me is going. Page number 15, Lordship, NI Act case. They have instituted
No, for the
against
de
me.
facto complainant. You have received the payment.
No, Lordship, we have received only a part payment of rupees 2,40,000.
Yes.
But what I am to state over
Yes,
here
yes.
is that in the order dated, I don't know which page it is.
Page 14, page 14.
Page 14,
I have not
Lordship.
served a copy, Lordship.
Anyway, you see, this is the order of the sessions judge, not by any coordinate bench.
Yes, Lordship.
So, definitely,
there, Lordship, what the
you try to settle the matter.
Lordship, I will pay whole
They have
amount,
given
Lordship.
an anticipatory bill with the one condition that the payment has to be made within 20th March 2024. Thereafter, they extended this anticipatory bill by stating that they will give them 2 months time and they will pay. But still they didn't pay. Therefore, the anticipatory bill has
Anyway,
been
whatever it is,
rejected.
you see, this is the sessions court order. We can modify it also.
Yes, Lordship, but
That
Lordship,
that can
kindly,
be
Lord.
done. Yes, how much time you require?
6 months, Lordship. Within 6 months, I will pay whole amount, Lordship.
No, make some part payment within 3 months.
Lordship, Lordship.
Lordship,
Definitely, I will do.
they have been
How much is due?
around 7
Very
very beginning, he has been cheating. He has suppressed facts that.
You want your money back?
Yes, sir.
We are trying that. What will be your satisfaction if he's sent to jail? You'll never get your money.
But he has been for the last.
Esho. Madam, not 6 months. You're asking for 6 months. We'll grant you 4 months, 7 lakhs. You pay within 4 months.
Lordship, give me a chance of part payment, Lordship. Within 3 months, I will pay 3 lakhs, and within 3 months, I will pay 4 lakhs.
No, within 2 months, you'll pay 3 lakhs. Within the next 2 months, you'll pay 3 lakhs.
Lordship.
Whatever the, not 3 lakhs, the balance.
Balance.
The petitioner says that the dispute between the parties is completely civil in nature. Stop. The petitioner owes some money to the de facto complainant. Stop. He has already repaid part of the money. Stop. Around rupees 7.6 lakh is still payable. Stop. Paragraph. The petitioner had approached the learned trial court for anticipatory bail. Stop. The learned trial court had granted anticipatory bail on interim basis till March 12, 2024 on inter alia the condition that prior to that date, the petitioner shall fully repay the rupees 10 lakh that was due to the de facto complainant. Stop. The petitioner has till date paid approximately rupees 2.40 lakh. Stop. The order of anticipatory bail stands cancelled automatically as he was unable to pay the entire amount of rupees 10 lakh to the de facto complainant by March 12, 2024. Stop the paragraph. The petitioner says that some more time should be granted to him and he will make full repayment. Stop. Paragraph. Having considered the facts and circumstances of the case, we are inclined to grant some time to the petitioner. Stop. He prays for 6 months' time. Stop. We are not inclined to grant so much time. Stop. We allow the petitioner to repay the outstanding dues of the de facto complainant within 4 months from date. Stop. We grant anticipatory bail to the petitioner on interim basis till November. March 15. March 15. March 15, 2025. Stop. এটা কি dispositive করে দেবো? তারপরে accordingly করে দাও। হ্যাঁ, তারপরে লাস্টে কি বলো? In the event the petitioner fails to repay the entire dues of the de facto complainant, i.e. rupees 10 lakh, by March 15, 2025, this order shall automatically stand cancelled.
Grateful Lordship.
Disposed of.
Lordship, praying for a Passover.
Passover?
It's not my case, that's not.
59. Item 59. Yes, on behalf of the petitioner, Lordship. Charged under section 448, 326 and 307, 34 of IPC, Lordship. Lordship, in this case, Lordship, one person is granted bail by the learned court below, Lordship. Lordship kindly comes to FIR, Lordship, page number 12, Lordship. Lordship.
Yes.
Pipeline, Lordship.
Yes.
There is allegation, Lordship, there. আসামিগণ আমার বাড়িতে চড়া হইয়া স্ত্রীকে মারডাং করিয়া 2 নং থেকে 4 নম্বর আসামির সহযোগিতায় 1 নম্বর আসামি আমার স্ত্রীকে জানে মারার জন্য হাতে ছোড়া দিয়ে মাথায় মারে ও ঘাড়ে হাতে সামনে আঘাত করে। Lordship, total allegation in the FIR number which page? 1, Lordship. Page number 12, Lordship.
Yes, the
I am the
nature of injury.
FIR number 3, Lordship.
Huh?
FIR number 3, Lordship, I am person.
Yes, we have seen.
Two injury reports are there, my lord. This is the first from government hospital, and next, my lord, page 53 is from private hospital.
Any statement implicating this petitioner?
My lord, the victim statement, my lord, victim 161 statement is there, my lord, page 17, 17.
Injury is grievous.
Yes, Lordship. But all allegation, Lordship, FIR number 1, Lordship. I am not in the place of occurrence,
Page
Lordship.
17.
I am falsely implicated in this case, Lordship.
161 statement.
Charge sheet had been submitted, Lordship.
Petitioner is Mohammad Shahjahan Mia.
FIR number 3, Lordship.
Shahjahan.
Yes,
Not Shahjahan.
Shahjahan. But 164 statement also there, my lord, of the victim.
Naming him.
Yes.
Victim names him.
164.
Lordship, is the FIR, Lordship, kindly consider in the FIR.
Forget about FIR. FIR is not an encyclopedia. You know that much better than we do. Victim statement.
Yes, what is the victim statement? This is the witness statement.
My lord, page 124, 164 statement of the victim. 124.
154.
124, 124.
This is the victim, lovely.
Yes,
victim.
yes.
ওরা বলছে প্রথমটাকে ইয়ে করেছিল ভিতরে 54 রয়েছে কি করবে দেবে না
Yes, the other accused is on bail.
One accused has been granted bail by the learned court below. File number 4.
That is Soidul.
Janam Mia Lordship. Soidul is the custody lordship. Principal accused has been custody in lordship.
Janab Mia.
Yes,
means to Janab.
File number 4 lordship Janam Mia.
Mohammed Shahjahan Mia, order number possible.
No, charge sheet file.
Yes, lordship.
Yes,
This
file
take down.
on 31st of July.
Learned advocate for the petitioner and learned advocate. Learned advocate the petitioner and learned advocate for opposite for the state of West Bengal represent. Are learned advocates for the parties. Learned advocate for the petitioner submits that the allegations made against his client is not maintainable as his client is not involved. Learned advocate further submits involved. Learned advocate further submits that the principal accused is in custody and one co-accused person is enlarged bail by the learned court below. Learned advocate for the opposite party objects the grant of bail and draws our attention to the injury report. Upon perusing the injury report and the statement under section 161 CRPC of the victim.
164 minute.
164 statement under 164 CRPC of the victim. This we are of the view that although there are allegations against this petitioner, but considering his nature of involvement and the fact that the investigation is complete and one co-accused person is on bail, in the interest of justice, the petitioner should be granted anticipatory bail. We therefore allow the prayer for anticipatory bail made by the petitioner. Thus,
Hello. Lord, I am for the petitions, Lord, made with your lordships. Lord, the charges are under 80 and 85 of BNS, Lord, corresponding sections 498 and 304B. Now, Lord, the first petitioner, Lord, is the brother-in-law. The second petitioner is the mother-in-law of the deceased lady. Lord, the brother-in-law, Lord, got married 6 months back, Lord, residing separately in a flat, Lord, with his wife. In Siliguri, Lord, around 50-60 kilometers away from the place where the victim used to reside. And the mother-in-law is the petitioner number 2, Lord. She's a 65-year-old lady. Lord, the husband is in custody and 2 co-accused person has been granted anticipatory bail by your lordship.
Who are they?
Lord, the married sister-in-law and her husband.
They live separately.
They used to live separately. Even the first petitioner lives separately.
General. General. Charge sheet.
Charge sheet not read.
65 years old mother-in-law.
Yes, sir. Everybody else.
Very rich. The petitioner number 1 is the brother-in-law, and the petitioner number 2 is the mother-in-law of the victim lady. Stop. The petitioner number 1 resides separately about 60 kilometers away from where the victim lady used to reside. Stop. The petitioner number 2 used to resides in the same house where the victim resided. Stop. She is about 65 years of age. Paragraph. The allegation is of meeting out torture, which led the victim lady to commit suicide. Stop. Paragraph. We have seen the statements of witnesses recorded under section 161 CRPC. Stop. The allegations are general and omnibus in nature. Stop. We are told that 2 co-accused persons, being the married sister of the husband of the victim and her husband, have been granted anticipatory bail by this court.
Yes.
By this court. Stop. On an overall assessment of the material on record and the nature of allegations, and considering that the petitioner number 1 stayed away from the victim's residence, and the petitioner number 2 is a 65-year-old lady, we are of the view that immediate custodial interrogation of the petitioners may not be necessary so long as they cooperate with the investigating officer.
I am the petitioner. Lordship, after 10 years of marriage, this case was initiated, Lordship, under section 85 and 89, 1091, read section 34 and DP Act, Lordship. 3 persons was granted bail by this net code below, Lordship.
85 is 304B.
No,
85 is 498.
498 and 307.
498 and 302.
307.
307.
Yes, Lordship.
Yes, what is your relationship with the complainant?
Husband.
Yes, what are the allegations? Injury?
Not injury, there is no injury report, my lord. Investigation still in progress, my lord. Other persons are
Granted bail.
granted anticipatory bail from the court below. This petition is the principal. My lord, up to the court, my lord, general allegation.
General allegation.
All departments. Husband.
Injury report.
ইন্টারনেট শাড়ির আঁচল দিয়ে শ্বাসরোধ করে মেরে ফেলার চেষ্টা করে।
There is no injury report. That allegation is against the husband.
All the persons.
Against all the persons. Oh. Yes, please take down. Learned advocate for the petitioners and learned advocate for the opposite parties. State of West Bengal are present. Are learned advocates for the parties. Produce the materials in the case diary. Learned advocate for the petitioner submits that the co-accused persons are on bail, are on anticipatory bail, and the prayer for anticipatory bail made by the petitioner may be considered. Learned advocate for the opposite party, state of West Bengal, objects the grant of bail, but submits that there is no injury report. Upon hearing the learned advocates and considering the materials in the case diary, we find that the allegations made by the de facto complainant are general in nature and there is no injury report. Stop. Considering the nature of the offense, the period of investigation, and that 2 co-accused persons are on anticipatory bail, we are of the view that as there is no reasonable apprehension to abscond, in the interest of justice, the petitioner should be granted anticipatory bail. We therefore allow the prayer for anticipatory bail made by the petitioner.
Some condition imposed.
Yes.
থানা হাজিরা মানে
Yes.
once in a fortnight থানা হাজিরা।
আছে তো আমাদের।
All in all matters they are
Husband,
giving.
husband.
All matters
is
they are
what- that is
giving.
In all matters, we do that. আমাদের কি আছে once in a fortnight আছে না once in a week আছে fortnight.
My lord, I am for the petition. Lord, the allegation is under section 126 of BNS, my lord, 126 to 115 to 117 to.
What is that, IPC?
My lord, main allegation is 326, 307 and 379. My lord, there is a mall in city center namely Matigara, my lord. There are some pubs and bars, my lord. In a bar, there was conflict between two groups. My lord. That is all. And the bar is
Nature of injury.
Yeah, natural. Page number 41, Lordship.
cut mark above right eye. All of them, other accused has been ended on bail by the court.
Yes, sir.
Page number 9, 10, 11, 161
No,
statement of
the
the
nature of injury.
Nature of
Which page?
injury.
Yes, Lordship.
Page, nature of injury.
Not mentioned, Lordship.
No, where's the medical?
No,
Which
this is
page?
the reference. Himalayan Institute is the reference.
Yes, Lordship.
No medical report.
No,
After 3 days, he was medically examined.
not collected, Lordship. Please take it.
No injury report, no medical report.
And yes, 161 statement, which page?
Page 9, 10, and 11. The statement of the bar manager, Lordship.
The complaint is the bar owner, man. Petitioners are, my lord, very younger in age, my lord, 19 years
এই
old.
তোমার কি হয়েছে এগুলো বলছি ঘরে গেছে যদি কোনো বিয়ে দুটো বুকের খুব ঝামেলা দিয়ে দিচ্ছে
Conduct of the accused, Lordship, at right, 2 p.m. Lordship, in drunken condition.
Huh?
Conduct of the accused, Lordship, at night, 2 Lordship, in a drunken condition.
Yes, yes. Charge sheet? Charge sheet.
No, Lordship, charge sheet.
The petitioners say that the incident was a brawl between two groups in a bar which operates from a shopping mall in Matigara, in Jalpaiguri.
No, Lordship, Matigara
Matigara.
City Center.
Oh, Matigara City Center. Stop. There was no serious injury suffered by anybody. Stop. The petitioners are willing to cooperate with the investigating officer. Stop. Their custodial interrogation is not necessary. Paragraph opposing the prayer, comma, learned state advocate draws our attention to statements of witnesses recorded under section 161 CRPC. Stop. The allegations in the statements are general in nature. Stop. The allegations indicate that there was a fight between two groups. Stop. Strangely enough, comma, we don't find any medical report or injury report in the case diary. Paragraph. In view of the aforesaid, comma, we are of the opinion that immediate custodial interrogation of the petitioners may not be necessary so long as they cooperate with the investigating officer. Now we'll switch.
Item number 257.
Minor item number 7.
Okay, try your luck tomorrow.
Item number 237.
257.
Yes, tomorrow we'll take criminal matters. If possible, we shall take it up.
State is also present, madam, one matter.
You see, if we take one matters, we have to take up 5 matters. Civil matters cannot be taken up. Tomorrow, definitely, we will try our level best from the morning.
257. नहीं चलो चलो पास में चलो 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 258.
Well, I'm led by Mr. Shoptangshu Basu.
258. The restoration application.
Well, Mr. Basu is.
259.
Other side is not here.
Well, kindly see your lordship's order.
Inform the union, they will come now.
Kindly see your lordship's order.
Thou, fight thou.
Your lordship has already dictated the order.
Yes.
Well, your lordship has probably already dictated the order.
Dictated the order. What
Yes.
order?
Only thing, my lord, instruction from the central government was awaiting. The lordship was want to relegate the matter for a fresh decision because the reply has not been taken into consideration while considering my case.
Oh, cancellation of contract.
My lord, your lordship has dictated. Entire order is your lordship's file.
Dictator কোথায় ভাই?
Yes, there is an order in your lordship that is uploaded.
পড়েছিলাম কিন্তু মনে হচ্ছে ডিকটেশন দিয়েছিলাম মনে হচ্ছে।
No, we have received
On
it.
8, my lord has passed here. On 8. On 8 of this month.
Yes, do you have a copy of that order?
No, uploaded হয়নি।
Wow.
Was it
Yes.
signed?
No, I have received one uploaded
Yes,
copy.
uploaded, my lord.
Uploaded? দেখো কাণ্ড।
Yes, yes.
Copy থাকবে তো, copy.
Yes, I now remember, of course. Mr. Who was appearing? Mr. Mojumdar? No.
Mr. Mojumdar.
Nobody is
Your
here.
lordship's view was also that even if they don't consent, your lordship can pass this order.
Look, you get him, you inform him. As soon as he comes, we'll pass it over, we'll take it up. কোথায় আছে?
No, it's here, here.
Yes. The order বার করো। Last order দেখাচ্ছে। 8th of November order নেই?
But we received it, my lord. We have.
You have a copy?
Yes, my lord, a soft copy.
Tabakur, show it from your phone. You sent me that order.
The phone will be seized as exhibit.
Yes, but not you, us.
My lord, on the earlier date, your lordship has indicated.
Yes, our mind, our prime
My lord,
wish, yes.
I had gone back to the department. Department doesn't agree.
Very well, we'll pass our order.
Oh,
My lord,
thank you.
I have to hard out now. I have certain things to show you.
Sure.
My lord,
You think you can finish today, Mr. Mujumdar?
I will try, my lord, but it might be difficult.
Otherwise no point, because we'll be.
My lord, I will take some time, my lord.
We will not be taking up civil matters tomorrow.
Right, my lord, because it will be useless. Your lordship.
First half we'll sit, second half we'll sit singly.
It will be difficult for me to finish.
And second up there may be 3:30.
No, we'll sit singly anyway. No, Mr. Basu, Mr. Mojumdar says he won't be able to complete today.
Then, my lord, useless. Your lordship sent a
Useless. Let it stand over till the next circuit.
261.
261 এর কথাই তো হচ্ছে 261ই তো হচ্ছে
259 is showing in the board.
259 কেউ রেসপন্ড করেনি তো পাস ওভার হবে তো কে 259 এর কথা বলছে না সবাই 261 এতেই দাঁড়িয়েছেন
Lordship,
Or it about
Lordship, Lordship, am I
May
audible?
we know what
Lordship?
is the objection he can raise probably?
Mr. Vasu, what can we do? We had indicated our mind. Now he
Yes.
says he wants to argue. We can't stop Mr. Mujumdar from
No,
arguing.
not, my lord cannot stop, but only thing is kindly the impugned order clearly demonstrate that my reply has not at all been considered.
We have recorded it. This is on
He cannot,
record.
he cannot develop that.
We don't know. Actually, Likho. Read order dated November 8, 2024. Stop. Paragraph. Mr. Mujumdar, learned DSG tells us that his client is not agreeable to the suggestion that fell from the court on the last occasion as recorded in the order dated November 8, 2024. Stop. Learned counsel says that he would like to make arguments opposing contesting the appeal. Stop. To our query, he says that he may not be able to complete his argument today. Stop. If that is so, then it will be pointless to proceed with this case since today is the penultimate day of this circuit. Stop. Tomorrow, only criminal matters will be taken up. Paragraph. In that view of the matter, let this matter stand adjourned. Let this matter stand adjourned and be placed before the next available circuit bench. Sorry, Mr. Basu.
Yes, sir, but what my lord can do? Get full to mind.
Lordship, I beg pardon, Lordship, my matter was 258 and 259 because I was appearing in the other court, Lordship, so a little delay is there, Lordship.
And 269 for the appellant. There is a delay application.
Other side is there.
Copy has been served. Madam.
State.
It is on record. Madam. Copy has been served.
Mr. Again, state is not there in this matter.
Later delay be control. There is also stay application.
Affidavit of service you have filed.
Yes. On the
Sir,
last.
private respondent on behalf of the rights.
How much delay? 90 days.
Madam.
The section 5 to the Pratham.
Delay of 174 days. Madam.
Nobody is opposing. Esho. কোন ক্যানটা দেখে নিও this is an application for condonation of delay of কত বললো 174 days in presenting the appeal. Stop. Causes shown being sufficient, the delay is condoned. Stop. Can such and such is disposed of. Your writ petition has been dismissed.
Dismissed. Madam.
Appeal has to be heard. Mat Tana or Onno Can Tana.
Can 4.
What is Can 2 then?
Can 2 and 3 has been disposed.
Oh, Can 2 ta bhul kore ache. Can 1 is the section 5.
Yes, ma'am.
Can 1 ta section 5. Can 4 ta now, Mat ta now, or Can 4 ta now. This appeal has to be heard. Stop the. The appellant's writ petition has been dismissed by the learned single judge. Stop. The appeal has to be heard. Stop. Paragraph. Let requisite number of informal paper books be prepared within 2 weeks. 2 weeks, incorporating all papers that were available before the learned single judge. Informal paper book.
Yes, ma'am.
Before the learned single judge. Stop. All formalities are dispensed with. Stop. Since you're the state.
Only with the private respondent.
Since the private respondents are 1 or 2?
8. One private.
One private. Since the private respondent is represented, notice of appeal is deemed to have been waived insofar as that respondent is concerned. Stop. Let notice of appeal be issued to the other respondents. Paragraph. Liberty to the parties to mention once the appeal is ready for hearing. Can Forta dispose of করে দাও?
Good.
Your Lordship, I appear for the appellants. I was humbly praying, let the matter appear in the next circuit bench.
On the prayer made on behalf of the appellant, let this matter stand over till the next circuit.
Much obliged.
Yes, Lordship. Honorable the appellant, Lordship. I filed an extension of interim order, Lordship.
Have you served?
Yes, Lordship, I have served, Lordship.
The interim order is operational till what date?
Lordship, 30th September 2024, Lordship.
Expired already.
Yes, I have filed the 26th September 2024, Lordship.
You are for the department?
Yes, Lordship.
Have you filed affidavit of service?
Possibly they were appealing on the last floor.
No. Affidavit of service showing that you have served the application for extension of interim order?
They were present on the last occasion, we have served them on email.
Email also.
They have received, they have also.
This, which is this can?
Can 3, Lordship.
Can 3 to know. This is an application for extension of the interim order that was passed on July 30, 2024 at the time of admission of the appeal. Stop. Paragraph learned advocate for the appellants says that notice of this application has been received by learned advocate for the respondents. Stop. However, nobody appears for the respondents. Paragraph. Let the interim order that was passed on July 30, 2024 and which stood expired by efflux of time on September 30, 2024, stand reinstated and continue till January. Till the end of January 2025 or until further order, whichever is earlier. Can dispose of.
The matter, my lord, I have lost in the learned.
Yes, who is on your other side? State of West Bengal. You are appearing? Yes. What do you say? You have a condonation application?
What is can 2 for? Can 2 is for what?
And the delay has already been condoned by the earlier court.
Are you ready? No. Paper book has been filed.
No direction.
File informal paper books. That makes life easier for the judges to handle papers.
All have been annexed with the.
Everything is there. So this can be treated as the paper book, informal paper book, but they are not ready. The learned advocate for the appellant says that all the pleadings that were available before the learned single judge have been annexed to the stay petition. Has been annexed to the application for appropriate relief filed in this appeal. Stop. Let the application be treated as an informal paper book. Paragraph. On the request made on behalf of the state, comma, let this matter be listed again before the next available circuit bench.
Grateful.
I am for represent by law. But this is a case where Lordship would kindly recall where the.
On behalf of the private.
I am opposing this. I am opposing this. Any prayer for adjournment? No, my
Next
lord.
available, sir.
No, my lord. Why I am opposing this? This has been going on. Now, my lord kindly remembers the Pradhan was directed to file a report.
Yes, yes, there, Pradhan has
So
come.
his presence is more important.
Let the report be filed, let it be circulated. Consider and come back.
Yes, my lord. Let the report be filed.
Yes. Now file, lekho.
Well, report
Dekho.
is not there. Is something on a
What is this?
letterhead.
This is our report.
Consider it, come
Very well,
back.
my lord.
Report filed by the Pradhan of the concerned Panchayat in terms of direction of this court be kept with the records. Stop. Let copies of the report be circulated amongst learned advocates for the other parties.
My lord, may, sorry to interrupt. My learned friend had handed me over this written in Bengali. And this has been deliberately done.
No, that I don't know. If the Pradhan is not proficient in English, what can I do?
The report, my lord, if your lordship accepts it, my lord, I have absolutely nothing
It
to
is in
say.
Bengali.
Yes, kindly says Dona Jama. He
Get
has
a
not
copy
even handed it over.
To get it some translation.
He has not even handed it over.
No,
If there is some.
within 7 days, you will provide English translation of this report to the learned advocates and will file that translation when the matter next comes up for hearing. You will. Paragraph. Learned advocate of the appellant.
I'm the appellant.
Learned advocate for the appellant makes a grievance that the report is in vernacular language. Stop. He is correct. Stop. The Pradhan is directed to make available authentic translation, English translation of the report to all the other parties within a fortnight from date. Stop.
Within 1 week.
Within 10 days from date. Stop. And English translations shall also be filed in court when the matter is next taken up for hearing. Paragraph lists this matter before the next circuit.
My lord, praying for liberty to file an exception to this.
Paragraph, the appellant will be at liberty to file exception to the report filed by the Pradhan.
Grateful.
With copies to the other parties. Sorry? Next, you are the appellant. You are the appellant on the prayer made on behalf of the appellant, Apurvo. Let this matter stand adjourned and be listed before the next available circuit bench.
Lordship 269, what is the 71 are connected matters. In very for Lordship is kind enough to recall, a query was put to me by the court that whether a preliminary inquiry is done before issuance of the charge sheet. But I have inquired and there was a preliminary inquiry done, but it is not included in the stay application. Stay application. So I'm.
Mr. Majumdar, you have 40 minutes time left for civil matters. These three, I don't think it will be
No, my
possible.
lord, I have to answer this query at least.
No, that's all right. We'll take this on record and then we'll adjourn it. আমার ফাইলটা একবার দাও আগে কিছু অর্ডার রেকর্ড করেছিলাম
270
I start feeling very sad when the circuit comes to an end. because I'm very fond of this place.
So we also feel very sad.
You are not serious.
My lord, Mr. Vishal says the circuit may be extended for a month.
I'll give you the Chief Justice's phone number.
That 87 অর্ডারটা হবে যদিও তিনটা
এই লেখো 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 কি একই অর্ডার হয়েছে না একটাতেই অর্ডার হয়েছিল একটাতেই হয়েছিল বোধহয় we had asked Mr. Mujumdar from a learned DSG to ascertain whether or not before issuance of charge sheet, a preliminary inquiry was held by the concerned authority, stop, paragraph. Today, Mr. Mujumdar has come back with instructions that such preliminary inquiry was held, stop. He files. Hey, ki file kulun daw na ekta.
All the three respondents' name appear, 3, 5, and 6.
He files papers evidencing the holding of such preliminary inquiry. Stop, let such papers. He files documents for papers. Let such documents be kept with the records. Paragraph. Today is the penultimate day of this circuit. Stop. Tomorrow only criminal matters will be taken up. Stop. There is not sufficient time to hear out this appeal. Paragraph. List this matter once again before the next available circuit bench.
No, the respondents are different here.
Yeah, trust.
Respondents are?
There are 3.
Yes. But I have not said কি বলেছি রেসপন্ডেন্টের কথা বলিনি তো কিছু
The order will be same only in 3 separate files.
No, thing is that in the other two, no order was recorded on the last.
My lord,
petition.
just adjourned.
Just adjourned. So same today.
Careful, madam.
Same today.
But my lord, if today the penultimate day 3 orders are
করে দাও তাহলে এক কাজ করো এটা তিনটেতেই এই অর্ডার করে দাও
careful, my lord.
Lordship,
273, my lord.
274.
Madam, Mr. Honorable Chairman, can be appearing on behalf of the client, madam. Can you please refer to more, madam?
Are you mad? Are you serious?
Yes,
You heard us. We are taking only criminal matters tomorrow.
Not to the appearing.
Not today.
No, you are for the appellate. Yes, you are for the appellate.
Not today. Not today. Both 273 and 274.
Sorry, not.
Next appellant
272.
Hey, on the prayer made on behalf of the appellant.
Lordship,
Prayer-
item number 272, the service has not been affected, so I'm praying for next circuit, Lordship.
273 and 274 বুঝেছো? On the prayer made, huh? Adjourn for the day. At 272 te bolo, learned advocate for the appellant says that service is not complete. Stop on his request, let this matter stand adjourned and be placed before the next available circuit bench.
Grateful, Lordship.
75.
My lord, in this matter, I
Yes.
the
Made by Mr. Chatterjee.
Yes, my lord, I'm here. I'm appearing, Lord.
Yes, you complete?
I will be, my lord, within 15 minutes, because I know the constraint of time. I will try to cut short the matter, which is very much important, relevant. I will refer that order. But actually, this is a case. There is a my lord, circulation and publication on the YouTube channel.
Why don't we first see the order?
My lord,
as we...
I am just referring to why this case.
Yes.
This, my lord, this in the said YouTube channel, there is a video which has been published and circulated, which is very, my lord, derogatory and malicious and tarnishing the Honorable Chief Justice of India. There was a video. In that scope, FIR has been lost. Now, my lord, kindly see the first. I will take up the what is the contents of the FIR, then the my lord, the court below order.
my lord, in the MAT application, my lord, sorry, can 1, my lord. Can 1, my lord, at page 15. Can 1.
Yes.
My lord, kindly see the affair is on 13th/9/2024. Kindly mark the date, my lord, kindly. Then the sections are 267, 352, 353, 1B, C, subclause 2 of the BNS, my lord. I will read later on the my lord, what is the corresponding section of the I. For the moment, I am not.
Lordship,
My
may I
lord, kindly
intervene
come
for a
to
moment,
content, next page, 16.
Page
Lordship,
60.
may I intervene
No,
for a
16,
moment,
1, 6, my lord.
That is of can 1.
Lordship,
Yes, my lord.
Page
Lordship,
1.
am I audible, Lordship?
Can,
Yes, you are.
Only thing is that may I intervene for a moment? Lordship, may kindly see the order once.
I will.
That
Of
will
course.
apprise the Lordship.
Yes.
yes, my lord. My lord, I such and such, lordship got it, my lord, just chose it. I such and such, my lord, the then address. This lodged this written complaint against a reporter anchor named Shuddhoshil of Priyobandhu Bangla Media, uploaded and circulated an offensive video against the Honorable Chief Justice of India in pertinence to the matter of RG Court, which the Supreme Court took suo cognizance of the matter. The reporter anchor has mentioned above prepared a report and circulated the contents through communicable devices that are very much offensive, defamatory, and menacing in character. The manner in which the reporter addressed the Honorable Chief Justice of India is very disrespectful, and the full content of the said news report circulated by the reporter is false and caused annoyance, inconvenience, insult, injury, and criminal intimidation. Whereas the reporter anchor intentionally made the false report by distorting the original fact and misrepresenting the false information to create enmity and hatred toward the society. Not only that, the media with malafide intention circulated the news report challenging the power of the Honorable Chief Justice and also in imaginary way threatened the public to agitate against the Honorable Chief CJI solely. That the said circulation report where the reporter anchor alleged that the Honorable Chief Justice of India is not performing his constitutional obligations by delaying the process of justice to the public of nation. It was also alleged by the reporter that the Honorable Chief Justice is working as per his own hidden agenda and the CJI is intentionally lingering some cases, legal issues according to his own sweet will without considering the gravity of the cases and law of the land. That the reporter even alleged that CJI is acting biasly in some selective issues, thus by circulating the said video, the anchor intentionally, next page below, insulted the CJI of the country and the entire judicial system of the nation by provoking the public at large, which shall break the public peace and tranquility and created feeling of hatred, enmity, and doubt among the minds of the people of this nation. That the reporter anchor had stated in the report that the Honorable Chief Justice of India is the most tarnished CJI ever in our judicial history, and the Honorable Chief Justice shall immediately be impeached from the chair. That the reporter also stated that the hearing of the matter RG Court will not be listed before the Honorable Supreme Court and RG Court will not get justice until the Honorable Chief Justice is impeached from the acting CJI. That the entire report news is fake, which was circulated on social media to intentionally defame the Honorable. Which was the content that was published in his own the YouTube channel. It has been circulated. There are lakhs and millions of people of the viewers. This video has been circulated on 2nd September. RG Court incident took place on 13th August 2024. 9th August. 13th August. Anyway, my lord, what is the date? 2nd September, this video has been circulated, uploaded. 13th September, this affair has been lost. Just after a 10-11 days.
After how many days? This affair was
10-11 days.
10-11 days.
Yes. 13th September, this affair has been lost.
Yes.
2nd September, this uploaded.
That means published.
Yes. And kindly recall, my lord, in entire state, even across the country, even there was this my lord, anarchy.
with regards to this RG court situation.
Admitted.
Now, my lord, the now, my lord, kindly now come to the sections. My lord, what might it is troubling me and why I am agreed by. This is the reason I am coming. I am letting cut shorting the matter. My lord. 267, 352 remain as to 267, 352, 353 subclause 1 B C
এই
2.
দাও না BNS টা
My lord,
ওটা কি এটা CRPC টা ওনাকে দাও BNS এই
ভারতীয় ন্যায় সংহিতা এই যে না ন্যায় সংহিতা
এসিটাকে একটু বন্ধ করা যাবে?
এইটা
এসিটা একটু মুখে লাগছে বা উইংসটা একটু উপরে তুলে দেওয়া যায়।
Yes.
Yes, my lord. Section is 267, 352, 353, 1BC2. My lord, first I will read 352. 267 I'll come later.
252,
352, my lord.
352.
কি লিখে এটা বাবা ভারতীয় ন্যায় সংহিতা তো
My lord. I hand over my book, my lord.
Yes, I think so.
My lord. But it is marked, my lord. Kindly be excused, my lord.
352 পাওয়া গেছে দেখতে তো চলে আসছে 347
আমার
তোমার কি এই বইটা কোনটা দেখছো
একই তো ন্যায় সংহিতা আপনি 353
Well, Lordship, this matter, Lordship, can be cut short. An argument could be advanced by citing the order itself, why the order was stayed, why the FIR was stayed.
Oh, 151.
Yes.
Lordship got it.
Does that
We are not
disclose
well versed
any
with
of the
this news,
computable offense?
the amendment.
It will take some time.
Yes, even it's to some extent difficult to lord. 352, my lord. Lordship got it.
Yes.
Now, intentional insult with intent to provoke breach of peace. That was the, my lord, the heading. Whoever intentionally insults in any manner and thereby gives provocation to any person, intending or knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense, shall be punished with such and such. Lord, may I very candid? This is a non-cognizable, my lord, and the non-bailable. 352.
Non-billable.
Non-bailable, non-cognizable. Now, 353. 353, my lord, the sections which has been added, 353 subclause 1, B, C, and 2. This has been section added. Now, 353 kindly come. Statements conducting to public mischief. 1. Whoever makes, publishes, or circulates any statement, false information, rumor, or report, including through electronic means. So 353 subclause 1, my lord, well attracted. My lord, then B and C. Next page. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against the public tranquility. And similar, with intent to incite or which is likely to incite any class or community of persons to commit any offense against any other class or community. This section means non-bailable and also means cognizable. Kindly mark the cognizable. And 353 subclause 2, whoever makes, publishes, and circulates any statement or report containing false information, rumor, or alarming news, including through electronic means, with intent to create or promote, or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, custom, community, or any other ground whatsoever, feelings of enmity, hatred, or ill will between different religious,
This is also, my lord, the non-bailable and cognizable. Now, my lord, kindly examine the 267 section. Who 67, Lordship? Lordship got it? Yes. 267 is, my lord, intentional insult or interpretation to public servant sitting in judicial proceeding. Whoever intentionally offers any insult causes interruption to any public servant while such public servant is sitting in any stage of a judicial proceeding shall be punished with simple imprisonment for a term which may extend to such and such, my lord. This is also, my lord, non-cognizable and bailable offense. So, my lord, here, out of the 3 sections, 2 are non-bailable, 2 are cognizable, 1 is non-cognizable offense. My lord, in section, which is, my lord, in CRPC, in BNS 174 section said, BNS 174 subclause 4 says, where a case, what I am reading, and where a case relates to 2 or more offences of which at least 1 is cognizable, at least 1, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. So, my lord, here, by the affair of 13th-9/2024 discloses the cognizable offences. Discloses the cognizable offense. The moment on 13th September they disclosed the cognizable offense, police had registered this affair, my lord, under these sections. Because, my lord, it is the duty of the police, it is the law of the land. The moment the cognizable cases has been disclosed, immediately has to be registered. An investigation to be carried out in terms of the procedure, my lord. So, police had done this, and then in consequence, they had to, my lord, issued a notice for his appearance to substantiate and to produce some documents. That notice was issued, my lord, on 16th-9/2021. I have
Page 18.
My lord, must be, yes, right, your lord, you are seeing.
This is 13-9.
13-9, asking him to appear on 16-9, my lord. That is, your lordship will find 1, 2, 3, 4, 5, 6 line. You are directed to appear.
Yes.
That's why I said, because I'm skipping, my lord, that 16-9. But in the reply through a mail, he said that I need a more time. And then he sought for a time.
Anyway, documents were sought for from this person.
Exactly. These
How
are the
many documents did you
A,
see?
B, C, D, F.
A, B? No, not A.
You will not commit any offense in.
No, which document?
Lordship, it's a completely wrong statement made.
How many documents?
135-2 notice was issued.
How many documents did you
Lordship
see from
is
this
being-
person?
My lord, I am coming. 16.
Lordship,
You will produce
35-2
all relevant
notice was
documents.
issued.
My lord, I am coming.
I expect the submission.
Please
should
don't
be fair,
interrupt me
Lordship.
in this way. This is not the way to
But this
address
is
the
not the
court.
way to misguide the bench. Please
Anyway,
say
please
that
submit.
35-2 notice was issued.
Mr. Chatterjee,
Lordship.
we will not decide this case ex parte. If we at all decide, we'll
Lordship.
hear you.
My lord,
Point out,
that
you point out whatever erroneous submission is made on behalf of the appellant. As it is very difficult to hear you virtually. You are not very clear. The sound quality is not very good. Please don't interrupt. We'll hear you. If we decide the case, obviously we'll hear you.
Now you see, you
My
have
lord,
stated
yes,
that you
kindly-
would produce all
My lord,
relevant documents
Yes,
for
my
the
lord.
purpose of
It is
investigation.
for the purpose of, my lord, the
Investigation.
investigation, my lord.
So
These are the direction were given, police.
definitely, but actually, you see, some specific documents.
It
are
was
sought
not,
for.
my lord, because kindly see on 13th we received and then 13th the notice was issued. That's why we will examine, we will carry out the investigation.
Yes,
This is
yes.
the reason.
The person
So,
will appear.
Exactly, my
You
lord.
will
That's-
also
this is not
comply with everything you will do.
This is not a case, my lord. This is not my case.
Documents.
Yes, so notice was issued to him, and then definitely he has sought for a time. Then, my lord, on 20th-9/2024, my lord, he has filed this writ petition
Yes,
before
which
this honorable
page?
court.
Okay.
On 17th,
Challenging this notice
challenging the
Yes.
notice and FIR.
and FIR.
For quashing. Read file for quashing of the FIR and challenging the notice on 17th itself of the next day.
And the learned judge has quashed it.
Not
No.
quashed it.
Interim,
That
any,
the
what is the interim order
yes.
passed?
Now, my lord, kindly come to the order impugned. My lord, first, before I come to the impugned order, I would like to hand over the in between the order passed by the learned judge, my lord, court below. My lord, may I hand over the two orders? My lord, sorry. My lord, kindly turn out the second my lord, page. That is the order which I have handed now just now. The order dated 25th September 2024, my lord.
Yes.
20th September, my lord, second running page. The very first day, my lord, the police are restrained. Lordship got it, the last from bottom.
Page 25/9, and that is 25/9.
No, my lord.
Order dated.
Order dated 25/9.
Yes.
Second page.
Internal page 2.
Page 2.
Second last paragraph.
Page number, Lordship.
The police are restrained from taking any step in
So
response to subject.
which page you are referring to?
FIR till 4th October 2024 until further order, whichever is earlier. So, my lord, in the 25th September, so FIR was registered 13th September, notice issued on 13th September, asking him to appear on 16th, 17th he filed a writ petition, 25th there is an order of prohibitory order from the learned court, my lord. Now, my lord, what is the order into? MAT, it has been annexed. Lord, I will skip straight away. I'll come to page 3, running page 3, Lord, of the order annexed in the MAT. Lord, Justice Chaudhary, I think.
Yes, page.
Lord, the order.
Okay, this is the impugned order.
Yes, my lord, the impugned order.
So certified copy must be here.
Yes, this is the running page 3. MAT, it has been annexed with the MAT, my lord.
Yes, running page 3.
Page 3, paragraph 10 of the said order, my lord.
Paragraph 10, yes.
As regards the complaint filed by Otri Sharma, it appears that the entire allegation revolves around the judicial proceeding suo motu taken up by the Honorable Supreme Court in connection with a brutal incident which took place in the Arjikar hospital. Several mass protests and agitations are taking place in the state, country, and even beyond the boundaries of the country from the very next day of the incident. There are various versions of the incident that are doing the rounds. The manner in which the general public has got themselves involved in the mass agitations reflects the views of the public in general and not of an independent individual. Then, my lord, 12. I'm skipping paragraph 11, 12. The court has conversed with the de facto complainant, Otri Sharma, who was present virtually. My lord, in the earlier order, he is directed to appear virtually or personally. He disclosed himself to be the legal practitioner and submitted that he was concerned with regard to maintaining the dignity and majesty of the judiciary. Then, my lord, kindly come paragraph 14. The court is not at all convinced how court has arrived. There was no case diary even called for, no daily diary even was produced, nothing. But court said convinced that there is any likelihood to cause fear or alarm to the public or to any section of the public to commit an offense against the state or against the public tranquility by the act of the petitioner. The right to free speech ought not to be curtailed by putting threat on individual to initiate criminal proceeding. According to the learned judge, FIR lodging is a threat. 15. The instruction forwarded by the inspector in charge Siliguri police station, it has been instruction to me, Mila. In connection a case number such and such, does not mention whether the public or any section of the public committed or tried to commit any offense in furtherance to the video which was uploaded by the petitioner. That would be reflected in the CD case diary. It is a mirror. It was the instruction from the police station, the police personnel, that this is the progress of the investigation, which I have handed over to the learned judge. Now, my lord, paragraph 60. As regards the allegation of airing offensive, defamatory, and menacing report against the Honorable Chief Justice of India, The police could not have taken steps in response to such allegation till there is any complaint lodged by either by the Honorable Chief Justice of India or upon instruction of the Honorable Chief Justice of India. My lord, with regards to our 267, that is the Honorable Chief Justice of India. If he is being aggrieved, then he can file. But here the section, even my lord, in the Honorable Supreme Court, even in other, my lord, the false and the malicious, my lord, the video uploaded in the same issue, the cases has been initiated by the Honorable Supreme Court, even at the instance of the Honorable Chief Justice of India. So, my lord, 267, the person being aggrieved, the Honorable Chief Justice, definitely. But section with regards to, my lord, the 353 subclause 2, 353 is B.
Yes, what is there 353?
My lord, which I have read. My lord, I'll
That is the cognizable and non-bailable.
cognizable,
353.
353.
Yes, 353.
2.
No, 3.
353. 353B.
353B.
1B. 1B.
Yes, so that is cognizable
Yes,
and non-bailable.
Yes.
No, here you see, this is an admitted position. There is derogatory remarks upon the Chief Justice, interference in the administration of justice. Definitely, on the face of it is appears. But how far this section is applicable? That is the only question.
353.
Yes, yes.
That is the police to investigate.
No. How
That
far?
police will, that is the
From-
court
no,
cannot
from
sitting
the-
over the my lord,
From that allegations.
kindly
whether
353
this-
one again I am reading
whether
B.
that section is
B.
undoubtedly it's a derogatory remark.
B. Kindly read B. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public. So, my lord, by of this circulation, that is a cause of fear or alarm to the public, whereby any person may be induced commit an offense against the state or against the public tranquility. Number 2. With intent to incite or which is likely to incite any class or community or person commit an offense against any other class or community is a provocative. 2. Whoever makes, publishes, circulates any statement, report containing false rumor or alarming news through electronic media. So remember, this is the reason 353 subclause 2 is well attractive.
Where is the other section which you relied?
267 1.
267.
That is upon the person being aggrieved, the Honorable Chief Justice. There are 2-3 sections has been incorporated.
Yes.
One is cognizable, 2 is cognizable, 1 is non-cognizable. I said from this section that if the one section is a cognizable offense, then other would be deemed to be a cognizable. So, my lord, when the cognizable offense has been disclosed, it is the duty incumbent of the police to carry out the investigation. May I read further sections? Now come to the judgment, my lord. My lord Justice Chaudhary.
Yes.
No, my lord. I read 16, my lord. Now, my lord, 18. Though the court is not appropriate authority to advise as to how the police should deal with such complaints, but the court feels that the police have far more important issue to handle rather than spend time on complaints which do not disclose any proper offense and are more to gain public attraction. Because whether the offense has been disclosed or not, prima facie it has to be seen. The moment it has been prima facie has to be seen, police shall carry out the investigation. After causing an investigation, if it's find the genuinity of the complaint, end it with the charge sheet or end it with the FRT, whatever. That is the prerogative of the police fellow with regards to them carry out the investigation. 19. The court is not inclined to permit the police to proceed any further with the FIR that had been registered in response to the complaint filed by Otri Sharma. My lord, here I am agreed. Next, I am agreed, very peculiar, my lord. The respondents are directed to file an affidavit disclosing the necessity to proceed with such complaint in a mechanical manner without proper application of fine. Date is 22nd/11/2024. So, my lord, in one hand, investigation has been stopped after 10 days, my lord. No investigation could progress. By an order of this honorable court, my lord, say
police cannot proceed with the investigation. In the other way, I have to file an affidavit disclosing the necessity, how I will. Because now in the meantime, what police had done within the 7 days, that he has seized the pen drive, which the complaint has through a pen drive, through a pen drive, which has been supplied to the authority. First, he has made a seizure. Then, my lord, he has done. May I hand over the what he has done in subsequent to that? Just 2, 3. Because a very short period, my lord. Very short period. Within that period, what police has done? The cyber crime, 1, 2, 3, 4, 5, 6, 7, 8. First is seized. Seized, lordship, got is seized 1. Column number 1. 1, 2, 3, 4, 5, 7, 8, 9 line. 9th line. First page.
Yes.
9th line, seized, Roman 1. One pen drive containing video footage of YouTube post by such and such person.
You seized from whom?
From the complainant. Then 2, seized. Then what, subsequently what he has done? Cybercrime PS, Siliguri Police Commissionerate, for supplying the details of social media site, YouTube. That is the YouTube portal's code. Then why Matigara PS number such and such? In response, Inspector in charge Cybercrime PS sent a mail to the administrator YouTube LLC 901 Cherry such and such, requesting the authority to provide the YouTube account details having URL number, white office memo number dated 14/9/2024. Till then, my lord, this has been carried out. Thereafter, because of the matter is in season before the honorable court, my lord, thereafter we could not progress further, my lord. In the meantime, now, my lord, there is an embargo that police cannot proceed with the investigation. I am agreed by 1. Number 2, if I cannot proceed with the investigation, how I will file the affidavit disclosing the what actually happened is my lord, Justice Chaudhary's query, whether the section of 353 is being attracted or not. Then with this, my lord, whether this genuinity of the social media, my lord, the contents of the say YouTube my lord, contents which has been uploaded. So my lord, now, my lord, because I'm constant of time, my lord, straight away I will refer a judgment, my lord. That is the 2021-19 Supreme Court 401. Before that, I am just referring the Lolita Kumari well-known case, 1 paragraph. 2014, 2 Supreme Court cases. Still 2024, the constitutional bench order is Lolita Kumari. Kindly come straight to the last page, page 61 of the same chapter, Lolita Kumari.
Yes.
Now she's got it. Conclusion directions.
Page.
Last page. That is 61.
Page.
Conclusion direction. That was the direction. What direction say? We hold the registration of FIR is mandatory under section 154 of the code if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such situation. Then we I'm skipping 120.4. The police officer cannot avoid his duty of registering offense if cognizable offense is disclosed. Action must be taken against the erring officer who do not register the FIR. The information received by him disclose the cognizable offense. There are other conditions, guidelines. I do not wish to stretch further. So, the police authorities, the moment they disclose the cognizable offense, register, started investigation. That has been stalled. Now, my lord, 2021 Niharika, my lord. Landmark judgment, my lord. May I hand over? My lord, in 2023,
my lord, the Honorable Justice Bela Trivedi and my lord Justice Dipankar Dotto is also reiterated the same fact with regards to the my lord Lolita Kumari, which I am not handing over because same fact has been reiterated in 2020.
FIR has to be registered, but from the FIR, whether an offense is made out or not, yes, definitely the police authority has acted in accordance with law, they have registered the FIR. But now, in any FIR, you see, it is always subject to challenge, whether it should
I'm
be
not here.
sustained or quashed or whatever it is.
I'm not here.
Yes.
That is always within the domain.
Police authority cannot be blamed for registering the FIR.
No. But the only mere registering of FIR
Yes.
cannot culmination into the conclusion of a investigation.
Yes. Sometimes you see so many offences, you see so many cases, FIRs are registered, that FIRs are challenged, that it does
Always.
not disclose the offence, or
Always.
whatever it is.
Always. They challenged it. Now the question is
Yes.
under the judicial scrutiny.
Yes, whether
Whether
it's 26 or any other revision.
Whether the
42.
investigation police, if the court can stall the investigation at the very nascent stage. This is my challenge.
Yes.
This
Yes,
is 2021 my lord Supreme Court. My lord, straightway kindly come the running page 447. Lordship got it, paragraph 19.
Yes.
As observed herein above, there may be some cases where the initiation of criminal proceedings, here, my lord, I will perhaps would be able to satisfy your lordship query. Where the
Which
initiation
judgment Lordship is referring to?
may be an abuse of process of law.
Lordship,
In such cases,
Lordship, may I know which judgment is referring to?
Yes, sure.
I'm sorry, I'm referring the full.
I'm sorry to interrupt.
2021 19 SCC, page 401.
Hmm.
In such cases, and only in exceptional cases, my lord, kindly mark, in exceptional cases, and where it is found that non-interference would result into miscarriage of justice, the High Court, in exercise of its inherent power under Section 482 and Article 226 of the Constitution of India, may quash the FIR complaint, criminal proceedings, and even may stay the further investigation. However, the High Court should be slow in interfering the criminal proceedings at the initial stage. That is, quashing petition filed immediately after lodging the FIR complaint, and no sufficient time is given to the police to investigate into the allegations of the FIR stroke complaint, which is the statutory right, duty of the police under the provisions of the Code of Criminal Procedure. There is no denial of the fact that the power under Section 482 is very wide, but as observed by this court, it is getting of decision referred in herein above. Conferment of wide power requires the court to be more cautious, and it casts an onerous and more diligent duty on the court. Therefore, in exceptional cases, when the High Court deems it fit, regard being had to the parameters of quashing and the self-restraint imposed by law, may pass appropriate interim order as thought opposite in law. However, the High Court has to give brief reason which will reflect the application of mind by the court to the relevant facts. It is completely absent, my lord. Now, my lord, kindly come page 455, 454, my lord. Four, 454, my lord. 33 paragraph.
Yes.
In view of the above and for the reasons stated above, our final conclusion on the principal or core issue, whether the High Court would be justified in passing an interim order of stay of investigation and or no coercive steps to be adopted during the pendency of the quashing petition under Section 482 or Article 220 of the Constitution of India, and in what circumstances and whether the High Court would be justified in passing the order of not an arrest the accused, no coercive steps to be adopted, during the investigation or till the final report stroke charge sheet is filed under section 173 CRPC, while dismissing, disposing of, not entertaining, not quashing the criminal proceeding, a complaint affair in exercise of power under section 482 CPC or 226. Our final conclusion are as 33.1, my lord. Very important. This is my case here. Police has the statutory right and duty under the relevant provisions of the criminal procedure contained in chapter 14 of the code to investigate into a cognizable offense. Courts would not thwart any investigation into the cognizable offenses. Next, it is only in case where no cognizable offense or offense of any kind is disclosed in the first information report, the court will not permit an investigation to go on. Here it is not the case, my lord.
That is 33(3).
3. 33(4). Power of quashing should be used or exercised in a rarest of rare cases, not to be confused with the formation in the context of a death penalty. A separate aspect. 5. While examining an FIR complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability of the genuineness or otherwise of the allegation made in the FIR of the complaint. 6. Criminal proceeding ought not to be scuttled at the initial stage. Then exception ordinary rules state 8. Ordinarily, the courts are barred from usurping the jurisdiction of the police. Since the two organs of the state operate in two specific spheres of activities and one ought not to be trade over the other sphere. It should like a railway track, my lord. The functions of the judiciary and the police are complementary, not overlapping. Then 12. The first information report is not an encyclopedia which Lordship even expressed half an hour before, which must disclose all facts and details relating to the offense reported. Therefore, when the investigation by the police is in progress, the court should not go into the merits of the allegation in the affair. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that the complaint affair does not deserve to be investigated or that amounts to abuse of process of law. After investigation, if the investigating officer finds there is no substance in the application made by the complaint, the investigating officer may file an appropriate report with summary. Then 33.50. When a prayer for quashing affair is made by the alleged accused and the court, when it is exercised power 482, only has to consider whether the allegation in the affair disclose commission of a cognizable offense or not. The court is not required to consider on merits whether or not merits of the allegation make out a cognizable offense, and the court has to permit the investigating agency police to investigate the allegation in the affair. Then, my lord, last paragraph 33.16. The aforesaid parameters would be the applicable and the aforesaid aspects are required to be considered by the High Court while passing an interim order in quashing petition excess of power 482 or 226. However, an interim order or stay of investigation during the pendency of the quashing petition can be passed with circumspection.
Not yet, that's what.
My lord, I have completed.
No, you have completed,
No, I
Mr.
understand.
Chaudhary. Without hearing Mr. Chatterjee, we
that-
cannot pass any
definitely
order.
That cannot be allowed.
Yes. So therefore, what to do? Interesting matter. I have at least.
Can I argue before your lordship there in Calcutta?
No, then we'll have to make it part heard.
Well, because already a substantial part I have completed. 90% I have finished.
You have finished. He has not even
There
started.
is a hardened part.
He has not even started. Mr. Chatterjee has not even started.
Otherwise, my lord, the court's time would have been, it has been.
No, we enjoyed listening to you.
That would be for academic purposes. No court.
I learned about this case. This is very helpful.
Very, very interesting case even. Very interesting.
This
Niharika.
three-judge judgment.
So, my lord, kindly make it part hard. I will, my lord, otherwise, my lord,
No, Mr. Chaudhary, the higher authorities frown upon that. I'm telling you. And we have to face the music. You understand when I say higher authorities?
I got it. But an administrative authority higher.
So-
No one is higher than
Yeah.
in judicial proceeding, my lord. Here in the state of Bengal.
We can't pass any.
My lord, 15 minutes can be spared tomorrow. Definitely subject to.
No,
I
but
cannot
then only hearing you will not serve the purpose.
deserve the judgment, my lord. But otherwise,
No, Mr. Chatterjee,
No, my lord,
will you
tomorrow-
finish in 15 minutes?
tomorrow, my lord.
Lordship, it is difficult. To a certain extent, it is difficult, Lordship, because there are, I will be arguing on the what point I am telling you, Lordship. Mr. Chaudhary has already referred to the sections of this Nyaya Samhita. I will be referring to the sections from the Nagarik Suraksha Samhita, which clearly gives some impediment upon the police regarding the offences committed against the judiciary or judicial officers. There is a clear embargo that police cannot, magistrate cannot take cognizance on that.
Sorry,
So there
let
is
us
a
record an
conflict on
order. We had,
My lord, I have disclosed my all.
sorry?
that. And Lordship, that if
Protect
Mr.
by an interim way, because the report we have to file by 22nd 11.
Affidavit.
Affidavit disclosing. My lord, may I very candidly I will submit. I will not arrest him. Allow me to cause an investigation and I will submit the report.
No,
I will not
that,
arrest him. No coercive steps with regards to any arrest. I will not. I am giving an undertaking. But permit me, because no court can snatch my power.
Lordship, the
It's
question
my
is,
statutory power.
we may
That's
well
where
agree
Lordship
with
I
you.
wish to-
Again, without hearing him, can we
That
pass
is
such
Then
an
will
order?
22nd I have to file. Otherwise,
No,
I may face
that we are thinking what we can do.
that kindly protect me in that scope.
Lekho. Today is the penultimate day of this circuit. Stop. Tomorrow, only criminal matters will be taken up. That too, in the first half, as in the second half, both of us propose to sit singly. Stop. Paragraph. With the ardent hope that hearing would be concluded, we had taken up this appeal for hearing. Stop. It is 4:40 now, 4:40 p.m. now. Stop. You have concluded, no?
Why I have concluded.
Mr.
My lord, if it is making up reply, if any, then I will make a reply.
Mr.
Law
Chaudhary, learned AAG, has just about been able to conclude his opening submission.
Yeah.
Stop. We have not heard Mr. Chatterjee, learned counsel appearing for the respondent oblique writ petitioner. Stop. Hence, we are not in a position to pass an order of stay of the order impugned as such, even if we are prima facie satisfied that such an order is warranted. Stop. Paragraph. However, Mr. Chaudhary makes a valid point that the affidavit that the learning affidavit or report, what is it?
Affidavit.
Report in the form of affidavit.
No, affidavit. What prompted us,
Yes,
necessitated us.
That the affidavit that the learned judge has called for from the respondents cannot be filed. No, has made a valid point that no meaningful affidavit disclosing the necessity to proceed with the complaint in question can be filed without making further investigation in the case. Stop. However, further investigation has been stayed by the learned single judge. Stop. That order is under challenge in this appeal. Paragraph. We are not staying the operation of the order impugned, as we have not heard Mr. Chatterjee appearing for the writ petitioner. Stop. However, we prima facie are of the view that without further investigation, no meaningful affidavit can be filed by the respondents in the writ petition. Stop. Hence, comma, the requirement of filing the affidavit, requirement of preparing and circulating the affidavit by November 22, 2024 is kept in abeyance for the time being. Stop. Let this matter, paragraph D, be placed before the next available circuit bench.
Till the disposal of the appeal, kept in abeyance till
For the time being, we have said.
Till further orders.
Till further orders, till for the timing will
Timing
do.
is always,
That will do.
that is sufficient.
Mr. Chatterjee, we have no time to hear this. We are not staying the order, but
My lord.
that portion
That
only.
I am not agree with, right? That I am not agree
The
with.
judgment cited referred shall be detained with the record. I will take back.
You take back. Or you can keep the record now, because we have not recorded the argument.
Then we have to again open.
My lord, sorry.
Yes.
But before my lord dies, my lord, I have just entered the link to tender my apologies, my lord.
No, that's all right.
No, my lord, I'm
That's
extremely
right.
sorry, my lord, my unqualified apology, my lord. I've embarrassed the bench, my lord.
That's all right. That's all right. Thank you. Thank you.
I'm obliged.
শিগগিরই পালাও না দেখতে।
Shorter copy.